Yeah. My lord, if time permits, my lord, I'm praying for taking up of 2 unlisted anticipatory bail application, my lord, at 2 o'clock if time permits, my lord. Grateful, my lord.
May I please, Your Honor? Your Honor, I would like to mention one unlisted bail application matter to be listed today.
Okay.
Yes. Much obliged.
Reserve a big mention for listing one CRP on 5th of August. Most of
Worship, I beg to mention item number 30.
item number
30.
13
30. 30.
30
For adjournment.
30. It's for hearing.
No, yes.
23 matter, but little old. Another day you want to.
Can it fix on 19th of August?
You're for the appellant,
No, exponent number 1.
respondent. You have informed the other side. Yeah. You're for the other side.
Yes, sir.
First, the learned counsel for representing respondent number 1 seeks an adjournment today and prays for listing the matter on 19th August. The learned counsel for the petitioner for the appellant concurs with the said submission. First, list on 19/8.
Your Honor, I beg to mention item number 27, Your Honor.
Item 27.
I've taken the consent from
It's a very old matter, but he's in jail or is on bail.
I have not
Not sure.
right,
Not sure.
right now, Your Honor.
But you need to please check up, huh? Because if it's in 19 matter, it's difficult to adjourn actually. When do you want it?
After 3 weeks, Your Honor.
No, little earlier. Huh? Little earlier. Take it after a week or so. After a week, you take. Okay. No, because old matter. Huh? Kindly check also whether he's on. The learned counsel. Your good name, please.
T. Roller.
Learned counsel for the appellant makes a prayer for adjournment of the matter. Full stop. The prayer is allowed, but however, as the criminal appeal pertains to the year 2019, therefore, the learned counsels on both the sides are requested to expeditiously conduct the hearing on subsequent dates. List on list after you can take a date if you want. It's gone already. That's okay. No.
Your Lordship.
Would you just a minute? No, would you like to take the date? Take the date.
Your Honor, then after 2 weeks.
Okay, but do it, huh? On the today is 3rd, no? Do it on 17th. 2 weeks. 17.
May it please,
Yes,
Your Lordship,
madam.
I beg to mention item number 22.
22.
I'm appearing on the behalf of this honorable. Lordship, the leading counsel is outstation counsel, and due to severe health issue, he could not come.
It is connected with the RSA also. 22,
Yes,
right? So both have to be adjourned.
Your Lordship, I am the opposite counsel in item number 23.
23.
Yeah. The fixed date may be given. It may be fixed on 10.
In the 22, item number 22, you're right. In 22, you are for the applicant, right? Your good name, please.
A. Jonglis, Your Lordship.
Learned counsel appearing for the applicant. Prays for adjourning the matter today as the leading counsel is outstation. And he could not come today due to some difficulties also. The learned counsel for the respondent, who is also the appellant in RSA 2 of 2026, within bracket item 23, does not oppose the amendment, oppose the prayer for adjournment, but prays for fixing a date. Next paragraph. List the matter on 10. 10/8. Okay? 10/8.
Your Lordship, I beg to mention another item. Item number 6. Your Lordship, the matter may be kindly adjourned because the counsel.
You are for petitioner.
Yes, for petitioner. The main counsel comes from Delhi. Due to his personal difficulty today, he could not make his way to Itanagar.
The learned counsel, Mr.
M. Kamjam.
Appearing for the petitioner, prays for an accommodation today, submitting that the leading counsel appears from Delhi and he could not come today. He would come physically,
Physically,
and that he would like to address the arguments physically first. The prayer for adjournment is allowed.
after 3 weeks.
List after 3 weeks on a date to be fixed by registry.
Obliged.
So all matter, however, do it.
There, please, my lord. We have other things in agreement, sir.
I-
Leading counsel is innovative. And Nicole is listed after.
You're for the petitioner. Petitioner. Learned counsel appearing for the petitioner submits that the lead counsel, who's the lead counsel? Oh, Modi. Learned lead counsel, Mr. Odin Modi, could not appear today due to some health issues. And therefore prays for adjournment of the same. Place the matter after 2 weeks on a date to be fixed by registry. No, we can give a date also if you want. We can give a date. After 2 weeks, on a date to be fixed by registry. Okay, interim order by so and so date stands extended till the next date of listing.
Item number 31, ma'am.
Item 31.
We are for the responding matter.
You for the respondent. Okay. You have informed the other side? And learned counsel for the, you for both the respondents. Both the for the respondent side, submits that the lead counsel or Orin Modi is unwell and seeks another date. It is submitted that the petitioner side has been duly informed. Matter is adjourned today. List after 3 weeks on a date to be fixed by registry.
Your Honor, in item number 6, there is an interim. It may be continue.
Yeah, that will do. Interim item 6, interim order extended till the next date of listing. Yes.
Item number 1,
May appear also.
Mr. Devi, yes.
This is an revision against the conviction. The petitioner before your lordship was convicted for offense under section 279, 337 and 304A.
I see.
Yes.
What is the highest sentence?
I 304A, 2 years.
3 years.
2 years.
2 years. He's on bail at the moment?
Yes, Mala, he is during the for the appeal, he was in jail. Now till that he is bail. Its operation portion is page 75.
Okay. You, for suspension of sentence, you will be
Yes.
filing a separate IA?
Separate IA is there.
Okay, it's there today.
Yes. Therefore, my notice may be go. But the only question is that whether the vehicles was in the IHP, that was not in the mind.
So we need not, should we dispose of the IA today or issue notice?
Maybe disposed of only for suspension.
Yes, Lordship, because they have already in the suspended during the trial also, Lordship. And
They are on bail.
also- Yes, Lordship. And Lordship, 2 years only, Lordship, the highest offense.
Yes, that's true. No problem.
But the
Yes.
notice may go to the respondent number 2, Lordship.
Yes. But we can dispose of the IA.
Yes.
Mr. S.K. Devi, learned counsel for the petitioner. He had learned additional people.
Lordship.
Stop. The petitioner has invoked the jurisdiction, provisional jurisdiction under section 438, 442 of the BNSS 2023 to assail the judgment and order dated 22/7/2026 passed by the learned session judge Teju in criminal appeal number 3 of 2025. Give a dash. Dismissing the said appeal against judgment and order of conviction and sentence dated 15/9/2025, passed by the learned GMFC Namsai in GR case number 3333 of 2000
Here is not
16.
here.
2016. I mean, full stop. By the said impugned judgment passed by the appellate court, the said learned court affirmed the conviction of the petitioner under section 279, 337, 304A IPC, and also upheld and affirmed the sentences of SI of 1 month and fine of rupees 1,000 within bracket in default SI for 7 days for the offense for the conviction under 279 IPC semicolon SI of 1 month and fine of rupees 500 within bracket default SI for 3 days for the conviction under 337 IPC and SI for 2 years and fine of rupees 2,000 in default 14 days SI for the offense for a conviction under 304A IPC. Full stop. However, the sentences were directed to run concurrently and the petitioner was also given benefit of set-off. Full stop. It is submitted by Mr. Deori that the petitioner was on bail during the proceedings and presently also he is on bail. Full stop. Issue notice upon the respondents. The petitioner shall furnish extra copies if necessary to the prosecution. Steps of notice shall also be taken upon respond number 2 by speed post. Full stop. In the meantime, we can call for the original case record, sir.
Yes, Lordship.
Call for the original case record of GR 333 of 16 and criminal appeal 03 of 2025 from the court of the learned JMFC Namsai. The appellate record would have gone back to this thing. Full stop. List on how many
After
after
receiving of the TCR,
after 4 weeks, after 3 weeks.
after receiving of the TCR Lordship.
Yes, yes. So list the matter after 4 weeks
Lordship.
on a date to be fixed by registry.
Obliged.
This interlocutory application
Yes, my lord.
has been preferred under section 438 BNSS for suspension of sentence and bail with regard to judgment and order dated 22/7/2026 passed by the learned session judge Teju in criminal appeal number 3 of 2025 upholding the judgment and order of sentence dated 15/9/2025 passed by the learned JMFC Namsai in GR number 333 of 2016. Full stop. By the impugned order passed by the appellate court, the conviction and sentence recorded by the trial court was upheld and confirmed. Full stop. The petitioner, then you write those sentences. The petitioner was convicted by the learned trial court under section 279, 337, 304A IPC and sentenced as follows. Sentence to ... Considering next paragraph, considering the nature of the sentence and the fact that the petitioner was on bail during the proceeding. He was on bail
Yes.
during the proceeding and presently also in bail. It is directed that till the disposal of the revision, the execution of the order of sentence dated 22/7/2026 passed by the learned appellate court confirming the order of sentence dated 15/9/2025 passed by the learned trial court shall remain suspended, and the petitioner is allowed to remain on previous bail. Full stop. However, the petitioner shall appear before the learned trial court, GMFC Namsai, and submit fresh bail bonds of rupees. How much will you? What was the bail amount which was given?
Yeah. 15 pounds.
Or should we grant fresh bail?
Okay.
Fresh-
Otherwise, previous is also do lordship. They-
Previous will do.
No.
Previous will do. We'll submit fresh bail bonds.
Okay.
Whereupon appropriate orders shall be passed by the learned trial
Okay.
court. Trial
Then it's
post. Post. List the matter after 4 weeks, along with the revision. Oh, sorry, this will be disposed of, I think.
Because IA may be disposed
Yes.
of, only IA lordship.
The IA accordingly stands disposed of on the aforesaid terms.
Alright.
Not necessary.
Item number 2,
My lord, this matter may be passed over for the time being, my lord. Obliged.
item number 3,
May I please, my lord?
Yes.
My lord, this CRPC is filing challenging the impugn show cause notice issues by the FX Customary Court of Arunachal Pradesh, my lord. Lordship, before I submit the fact of the case, Lordship, I'll take through the show cause notice, my lord.
Which are
number-
page 16?
Starting from 16, my lord, yes.
Okay.
3 show cause notice issues to the petitioners individually. May I just read out, my lord, content of show cause notice, operative portion, my lord. Second para, my lord. Operative portion, my lord. Second para, my lord.
Yes.
Content are same in 3 show cause notice, my lord. Therefore, you are directed to attend the NISI customary Nele fixed on 5 August 2026 before the instant effect customary court at Nele Nam at guest house of all Arunachal Pradesh Gauburi Welfare Association and Upper Dabam time 8 AM to place your justification and to adduce the evidence by bringing all the witnesses and evidence. Otherwise, the undersigned office shall proceed ex parte and ex parte order or judgment against you according to Arunachal Pradesh Civil Courts Act 2021, my lord. My lord, this so cause notice issues based on Arunachal Pradesh Civil Courts Act. Lordship is well aware that Section 15 has been amended by the legislative. Section 15 subsection 4 was inserted. So Lordship will take to the sections 15 subsection 4 of amended.
And in terms of the amendment,
My lord, this amendment was done in 2022.
yes.
Lordship, second page, para number, Roman number 3, my lord.
Yes.
After 4 provision to the subsection 3 of section 15.
Appeal from the village authority shall
Yes, my lord.
lie for
Appeal
the
from the village authority lies, if agreed to by the parties, shall lies before the inter-village territorial customary court, FX customary court, by whatsoever name called. My lord, this so cause notice which issues by the FX custom, they are the appellate authority, my lord. They cannot directly take up the matter.
No,
which-
actually, I passed the order in similar matter.
Yes, my
Another matter also.
My lord, this
Is
law
that,
is nowadays.
What happens is that, as per my understanding,
Yes,
the appeal from the village authority will lie to this court,
yes, my lord.
inter-village or apex.
Yes, my lord.
But as far as the inter-village territorial customary court is concerned,
Yes,
suppose you have a case where the people belong from different villages,
yes,
then one village authority would not be able to take up. In that case, they may have direct jurisdiction also.
yes, yes.
But for the appeal, the thing is that here you have to make out a case that your jurisdiction, the lies only
New
to
Delhi- New-
one village,
New
one
Delhi
village,
place.
one village.
Yes, my lord.
Why it has been, other persons from different villages?
No, no, my lord. The allegation is that my husband who is a petitioner, private respondent here in private respondent 2 here in my lord, who has launched complaint before the village authority of 1231 Nabam Tanium GB, head GB of the New Delhi village 2, my lord. That is page number 32, 23, my lord.
Let me read this order,
So,
so cause
yes.
notice.
Page 23, my lord.
Just a minute. I'll read, let us go through this order. See the forwarded case. This, the complaint was lodged by
Private respondent
Gyamar
for-
Jil.
Yes, Kyamarjil, who is a private respondent to
He's a resident of which village?
resident of New Delhi, my lord.
Huh?
New Delhi, my lord.
New Delhi.
Rayo village, my lord.
New Jil, but
Yes.
the Gyamar Jil
Kyamarjil is a resident of New Delhi, Rayo village, and I am also as a petitioner.
and Bamang Yapik, you're the
I'm
petitioner.
wife and I'm petitioner.
Yeah,
I'm
he-
also residing in the same house, my lord. Same.
So you are still married?
Yes, my lord.
Langro village.
Rayo
Langro
village.
village.
Rayo
He's
village.
stated to be a resident of Langro village.
Yes, my lord. So my lord, supposed to matter take up by the concerned village authority. So what happened, he has forwarded a matter to FX customary court, whereas no hearing was conducted in the village council, my lord. So directly matter was sent to FX customary court, whereas FX customary is itself, they are the appellate authority as per a law, my lord, section 15, subsection 4, my lord.
No, see, the thing is that, say, for example, the Court of Civil Justice Senior Division,
Yes,
they have original jurisdiction as well as appellate jurisdiction.
yes.
A court can have original as well as appellate jurisdiction. So the point is that if what are the situations in which the village customary court can also have original jurisdiction?
Yes,
Perhaps
well,
it may be in a situation where the persons are from different villages.
Yes.
Therefore, one village authority would not be able to decide. But if the persons who are subject of the dispute
Yes.
belong to the same village,
Same
then
village.
filing directly in the inter-village
Yes, my lord.
would be erroneous.
FX customer.
But if they are from different villages, then they still might have
Yes.
this thing. So at this stage, we issue notice
Well,
and you
this
can appear
notice
and
may be stayed, my lord.
because
directed to
you will
appear,
not be
my-
prejudiced. You appear and make your submissions there and bring this point also that
lord,
in what way you have the jurisdiction.
My lord, this authority, they have no directly intervenes the matter.
Because her address is given as Langro village.
My lord, this complainant is from Rayo village, New Delhi, my lord. So I am also residing at New Delhi, Rayo village, my lord. And my lord, my elder brother is residing at Itanagar, my lord. So this complaint supposed to hearing by this concerned GB where they have made complaint, my lord, on 29/6/26. Rather, my lord, without conducting the meeting, conducting the mail orders, he has forwarded the matter to the inter-village customary territorial court, my lord. So, my lord, this FX customary court is nowhere being authorized by any of the authorities, my lord. So, inter-village territory is the, my lord, circle level, my lord, where 2-3 village there is a dispute. So, that matter should be brought before the appeal before the circle level, my lord, inter-village territorial customary court. So here in the matter, my lord, without hearing the parties, they have directly brought the matter to this so-called FX customary court. So they have no such jurisdiction as per provision of the Arunachal.
You read the last few lines of the first paragraph. Kindly read. Let us read together.
My lord,
Let us read. You start from.
my lord,
You
in
know,
my
it may
page
throw
number
some light. It may, since you and your husband, kindly read from here.
my lord, page number 23.
No, 16 of the notice.
Okay.
Let us read it together. It might, because they have mentioned something there. Let's see. Let's see. Let's come to 16 and read from Yorna Pegu thereafter. Since. Got it?
Therefore, Nabam time.
No. Yorna Pegu. Since you and your husband. First paragraph.
Yes.
Sixth line from below. Sixth or something like 5-6 lines from the below. 1, 2, 3, 4, 5. Sixth line from below.
Yes, my lord.
Okay.
One law that Yorna Pegu for committing extramarital.
No, Yorna Pegu. Since you and your husband, just read that. Since you and your husband.
So, my lord, I have not found.
Anyways.
I cannot able to find that. Since
You and your
this
husband.
is regarding this one, my lord.
Since you and your husband were residing at Anioroya village,
Yes.
Nijuli, under jurisdiction, but now you are residing with so and so, Yorna Pegu at Langi village. Since the case is regarding inter-district case, therefore, Nabam Tangyung, the Gaumbura, has forwarded the case before the instant apex custody. That was my point actually.
Yes.
So that is why probably it has been forwarded by Gaumbura. right? It has been forwarded by the Gamura. So I think it will be prudent to, we'll fix a short date, let them appear and convince the court that
Suppose I may be appearing before these authorities. So if they will pass any order, my lord, so that will be defective order, my lord, because they are not, they are appellate authority, they are not original trial court, my lord, trial jurisdiction of the customer.
no, because it is clearly mentioned that they are conscious of this fact. You see, in the show cause notice, that is why I wanted you to read this and read sentence. They were conscious of the fact that this was an inter-district matter and it was referred by the GB of this village.
My
Right.
refer by my concern village GB, they have launched complaint before.
Nabam Tyongyong,
So they have to conduct mail or.
the Gaubura Nirjuli village,
Ni-
where they were residing as husband and wife. Now she is residing with this other person with whom.
I am not residing with other person, my lord. That's mere allegation which made by the my husband in his complaint petition, my lord.
Anyway, so
My lord, that's mere allegation, my lord.
please write. Heard, Mr. Learned Counsel for the petitioner. The instant revision has been filed invoking Article 227 of the Constitution of India against a show cause notice dated 16/7/2026 passed by the Apex Customary Court of Arunachal Pradesh, Upper Dobam Karsinga District, Papumpare in the state. Full stop. The notice is dated, we have written already, no? Notice dated 6, full stop. It appears that the petitioner and the respondent are husband and wife. The petitioner, the petitioner number 1 is the wife of respondent number 2. And the respondent number 2 lodged a complaint before the village authority with certain allegations against the petitioner number 1. And subsequently, the show cause notice, impugned show cause notice dated 16/7/2026 came to be passed. It is stated in next paragraph. The learned counsel submits that while notice may be issued, the show cause notice may be stayed, failing which he would be prejudiced as the proceedings do not have, as the Apex Customary Court do not have jurisdiction to try the matter as an original forum. Full stop. In this context, the learned counsel, referring to the amendment in section 5 of the
15, my lord.
section 15, sorry, of the
Section 4.
Arunachal Pradesh Civil Courts Act, Wide Amendment Act of 2022, to contend that after the said amendment, incorporated subsection 4 in section 15, clearly indicating that the appeal from village authority shall lie before the inter-village territorial customary court or apex customary court. Full stop. Next paragraph. Therefore, the main ground of assailing the impugned notice is that the customary forum which has issued the notice does not have jurisdiction to adjudicate the dispute in terms of vis-a-vis section 15 within bracket 4 of the AP Civil Courts Act. Next paragraph. I have carefully perused the notice. It is stated inter alia that this part you just underline. I have underlined at page 16. This you just lift. It is stated in the notice that The respondent number 1, Gyamar Jil, is residing at Ania Rayo village in Nirjuli under the jurisdiction of Nabang Tangyum, the Gaubura customary judge. Semicolon, but the petitioner is now residing with another person at Langi village under Neori circle. And that the case is regarding inter-district. And therefore, the said Gaubura, namely Nabam Tangyung, has forwarded the matter to the Apex Customary Court. And accordingly, the forum has taken cognizance of the case. Next paragraph. In this context, the learned counsel submits that though such allegations have been made, but they are staying together now also.
Yes, my lord, we are in same resident whatsoever allegation.
That the petitioner and petitioner number 1 and respondent number 2, being husband and wife, are staying together at Nirjuli village.
Ania Rayo Pala.
And therefore, the jurisdictional Gaubura would be the appropriate original forum to adjudicate the dispute. But I am not so convinced. We'll stay it for 2 weeks. We'll stay it for 2 weeks. But I mean, this is the whole issue actually. Let them appear, but we'll stay it for 2 weeks.
My lord,
No
if,
problem.
will appear on 5, my lord. So this matter will be in process. So they will conduct the mail. My condition, my prayer, my lord, if suppose the concerned village authority will call for.
That's okay, no problem. Issue notice.
Definitely will take participate, my lord,
Mm.
in my concerned jurisdiction, my lord. My lord, they have no any such jurisdiction, my lord.
But this aspect, it's not so black and white, because they may have.
My lord, there is an allegation that the person is residing in Kurungkame district. So if before.
That's an allegation that you have denied. That is why, for a limited period, we'll stay the notice, no doubt. But if they come and say that this is indeed inter-village matter, if this indeed turns out to be an inter-village matter, then they might have jurisdiction also, right? Because I'm at the cost of repetition, I'm saying that this 16 says that this will be to hear appeals from village council. This is the authority. But it does not say, that amendment does not say that it will not have any original jurisdiction. It may have, okay? So anyway.
My lord, this Navam Tanyam can summon to the parties where allegation made by.
I mean, no, he only, forwarded. He thought that, just bear me out one. He thought, Mr. Navam Tanyam, he thought that he does not have jurisdiction. That's why he forwarded. So that is what has to be decided by this court, right? Which is the right from issue notice upon the respondent. I'm telling you, I'm staying it for 2 weeks.
Yes.
Though I'm not fully convinced, but for a limited period, we are staying it. Because this aspect has to be sorted out.
Yes.
Right. There, before you go into the merits. The main thing is the dispute. Forum is there.
Husband made allegation that I have wrongfully sold plot of land, which he has already gifted me in the year 2024.
You just
I have
insert one line. Apart from this, the allegations. Apart from this, the respondent number 2 has also alleged that the petitioner number 1 has unlawfully sold plot of land.
Which he has already gifted me in the 2024. I have also enclosed the gift with mine.
In this context, the petitioner side contains that the said plot of land was gifted to her by her husband. Just insert it in that allegations. Last. Issue notice upon the respondents. Respondent number 1 is a state.
Yes.
You the state. Extra copies shall be furnished to the learned government advocate if necessary. Steps of notice upon respondent number 2 shall be taken by speed post.
Yes, speed.
The petitioner is also petitioners. Who are the other 2 petitioners? Other 2.
Other 2 petitioners, one petition number 2 is my elder brother, which my husband.
Elder brother and this person.
And 3 is the person whom made allegation that I have extramarital affairs.
The petitioner side is also at liberty to resort to justice service, in which case, however, the compliance affidavit shall be filed. Till the returnable date, the Impugn notice, show cause notice dated 16/7/2026 shall remain state. Full stop. List the matter after. Will not give a very long time because this aspect has to let them come and appear after maximum 3 weeks.
After that.
List the matter after 3 weeks on. You can fix a date.
All right, my lord.
1, 2, 3. 24, 24/8.
All right.
Huh?
Leave here.
Passover matter, item number 2.
Your Lordship, if I may, Your Lordship, I have also filed this revision under 227, Your Lordship. If uh, Your Lordship has seen the Civil Code Act and the subsequent amendments, I would still like to provide.
Better to keep one copy here, no, permanently. You keep needing this, no, Santosh. AFR and this, you keep it along with the amendments.
Your Lordship, since the judgment and order was passed only on the basis of the preliminary objection made by the parties, Your Lordship, with regard to the jurisdiction, Your Lordship. So the court has not gone into the merit. I'll just narrate the gist of the story, Your Lordship. There was a allegation made in a social media by the petitioner, Your Lordship, against the respondent, and respondent subsequently filed a complaint against him in the village, before the village.
Defamation.
Defamation. Your Lordship. Before the village authority, Your Lordship will find the translated copy of the village authority's order at page number 25A, Your Lordship. I won't,
25A.
yes, I won't read the entire context, Your Lordship, only
Go ahead.
that some fine were imposed to the petitioner in this.
You want to read the entire one?
No, Your
No,
Lordship.
you don't want.
So some fines with regard
So,
to.
let me just glance
Yes.
glance through one.
Yes, Your Lordship.
All the GBs had gathered to the allegation made by Iman against one who is the private found from the termination. Oh, it's own brother.
Yes, Your
Own
Lordship.
brother.
On. Now,
Since the
subsequent-
allegation is serious, fine of
Fine,
one Mithun and or 150,000.
yes.
And brass
And-
metal plate, a fine of man was directed that shall not add surplus to any social media forum.
So now we are not exactly dealing with the entire case on merit, Your Lordship. Subsequently, what has happened
This
was,
was taken up in appeal
yes, this was taken up in appeal. We
to
had filed an
the
appeal.
civil
Your Lordship.
judge.
The notice
The
will.
appeal slide to civil judge, junior division, senior division, depending on pecuniary
Yes,
jurisdiction.
yes, Your Lordship. And also the existence of.
And
the
junior
court-
division is up to how much
Your Lordship,
from Keba? In
Your
case,
Lordship.
just by the way, I'm asking. If you're not sure, it's okay.
not specifically known, Your Lordship. However, the civil, if Your Lordship is well aware of the Gauhati High Court Civil Rules Act, Your Lordship, that's what governs the pecuniary jurisdiction. Your Lordship. Now, subsequently, both the parties has contested, Your Lordship, and a written objection was also filed to the appeal, Your Lordship. Now, if Your Lordship come to the impugned judgment, Your Lordship, judgment and order at page
page?
number 77.
Just a minute.
Now, while dismissing my appeal petition, Your Lordship, more particularly at page paragraph 10, Your Lordship,
This appeal was filed by
by the petitioner, Your Lordship.
Yes.
Petitioner herein, who was also the respondent in the village authority.
Okay, against this order of the village council imposing fine and all that,
Yes,
he preferred an appeal
Appeal, Your
petitioner, which was dismissed.
which was dismissed. Now, the dismissal was on the ground that the appellant court has made an observation that the civil judge senior division before whom the appeal lies have no jurisdiction to entertain the appeal, and only on that ground my appeal was dismissed, Your Lordship. Now, if I may take your lordship to page number 84, paragraph 10, your lordship.
Yes.
The Honorable Court has completely misinterpreted the.
Where
entire
are you
provision.
reading? 84?
Yes.
Starting
nu-
from between.
No, your lordship. If I may read the entire paragraph, your lordship. Having meticulously examined the APCC Act to 2021 and its subsequent amendments, this court is of the considerate view that third proviso of section 15(3) applies exclusively to appeal cases which were already pending before the Court of Administrative Officers prior to the enactment of APCC Act 2021 and which were subsequently transferred to district judge or civil judge for final adjudication. To put it simple, section 15(3) of APCC Act 2021 empowers the district judge or civil judge to adjudicate only those specific appeal cases which has been transferred from the Court of Administrative Officers. This jurisdiction cannot be expanded to permit the district or civil judge for adjudication of the appeals filed against the decision rendered by the village authority after the commencement of APCC Act 2021. This is because section 15(4) of the Act specifically provides for filing appeal against the decision which has been passed by the village authorities post enactment of APCC Act 2021. Consequently, this provision cannot be interpreted as a general enabling provision that allows for filing of the fresh appeal before a civil judge against decision rendered by village authorities following the Act's commencement. Any such interpretation would render 15(4) of APCC Act redundant, as the legislature specifically enacted that section to serve as the exclusive legal provision for preferring appeal against the decision passed by the village authorities in the post-enactment era.
Just alternate. Just
Yes.
pause for a moment.
If your lordship is looking at the Act, your lordship, I'll just take your lordship to section 15, your lordship.
Section 15 of the original act.
Original Act. First, your lordship will see the Act of 2021, your lordship.
Yeah.
15 is the appeal provision, section
Yeah.
giving the appeal provision, your lordship.
Mhm.
15, first proviso is, if I may read, your lordship.
Mhm.
Provided that any appeal on civil suit pending in the courts of deputy commissioner can be disposed of by the concerned deputy commissioner under the proviso of Assam Frontier Administration of Justice Regulation 1945 as expeditiously as possible, but not later than 1 year from the date of coming into force of this act. So when this act came up, your lordship, all those appeal which was pending before the deputy commissioner was to be disposed of within a period of 1 year, your lordship.
Okay.
Now
And
subsequently,
from civil judge junior division, it lies to
no, your lordship.
civil senior division.
Subsequently, your lordship will take up the Amendment Act of 2022, your lordship. I have given the copy, your lordship.
Yeah.
2022, your lordship will see section 3 was where the amendment of
Mhm.
section 15 was made, your lordship. Now, if I may read 15(3) subsection 2, your lordship. If I may read, your lordship. In the second proviso, which we were dealing earlier, your lordship, of subsection 3 of section 15 for the existing entries, the following shall be substituted. Provided further, in case the deputy commissioners could not dispose of the pending appeal in their courts within 1 year from the date of commencement of Arunachal Pradesh Civil Court Act of 2021, they shall transfer such pending appeals cases to the Court of Civil Judge Junior Division, the Court of Senior Judge Senior Division, the Court of Additional District Judge, or the Court of District Judge, as the case may be, as per their territory and pecuniary jurisdiction.
So they were pending matters were
To be
allowed to be
transferred.
disposed of within 1 year. If not, then to this transfer.
Now, subsequently, your lordship will see the first proviso of this clause, your lordship. This is
Clause 4.
no, not for your lordship. This was the amendment was made, your lordship. The second proviso, which starts with provided also that, the second page, your lordship.
Provided also that.
Yes. Provided also that in case an appeal is transferred by the deputy commissioner, your lordship will observe, or preferred against the judgment of the customary courts in the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, the Court of Additional District Judge, or the Court of District Judge, as the case may be, such appeal shall not be set aside mainly on technical ground or procedural lapses, but in the interest of justice. Now, your lordship will see that those pending appeals, if not disposed of within a period of 1 year, will be transferred to the respective civil courts as per their territorial as well as pecuniary jurisdiction. Or, Your Lordship will see the Honorable Trial Court has completely missed this part, Your Lordship. Or preferred against the judgment of the customary court. Now, if any party is
Preferred by the litigant, that means.
yes,
From
Now-
customary court to the court of
To the
civil judge,
court-
junior division, senior division, additional district judge or
Yes.
district judge.
so even
Set aside appeals merely on technical ground or procedure in interest of justice.
yes. Now
Okay.
this, if Your Lordship take up this proviso into two parts, Your Lordship. First, the pending appeals before the Deputy Commissioner, if not disposed of, transferred to the respective civil courts. Or if the parties directly come and challenge the judgment of the customary court, they can come before the civil court of junior, senior, additional, as well as the district court as per there. So by this impugn order, the court has interpreted only the proviso, only the section 15(3), completely missing this part, Your Lordship, and to subsection 4. Now, subsection 4, if Your Lordship will see, after the port proviso to subsection 3 of the section 15, the following subsections shall be inserted. An appeal from the village authority, if agreed by the parties, shall lie before the inter-village territory. Now, while interpreting, Your Lordship, the Honorable Court has completely misinterpreted, stating that once the customary court pass an order, that has to be directly challenged before the inter-village inter-village customary court, or not before the civil court, Your Lordship.
Civil court.
Now, if I may take Your Lordship to another paragraph, which is also of great importance, Your Lordship. Paragraph 16, Your Lordship. At page number 87 of the impugn.
Page number?
87, Your Lordship. These two are the paragraphs where the interpretation of the entire act was made, Your Lordship, more particularly to section 15. Given the existence of legally recognized Bango is an apex body, Your Lordship, authorities and the district level Kaba authorities acting as inter-village territorial customary court in West Siang district, any appeal against a village authority decision, village level authority must first be preferred before the Bango level Kaba authority or the district level Kaba authority in accordance with section 15(4) of APCC Act 2021. Only after such customary remedies are exhausted may an aggrieved party approach the regular civil court, Your Lordship. This is where the particular misinterpretation happened, Your
The
Lordship.
thing is that doesn't this section, this subsection 4
Yes,
clearly state that the appeal from village authority shall lie before the inter-village territorial council?
yes. Therefore, Your Lordship, in the entire act,
Can you come to the civil court directly?
yes, Your Lordship.
Under what circumstance?
Under the same, Your Lordship, the parties are given the benefit to choose
Choice.
in this act, in this as per the APCC Act, Your Lordship. The parties are given the choice. Either you prefer directly to the civil court, or you can or also further go to the inter-village territory customary court, Your Lordship. There is no bar.
That choice comes from which section, according to you?
For me, the amended section, Your Lordship,
Of
15(3),
15(3).
15(3), subclause 2, second proviso. I have read, Your Lordship. Therefore, I have
In an appeal or appeal is transferred by the deputy commissioner.
or appeal against the judgment of the customary court in the court of, Your Lordship.
Provided also that
Yes,
appeal is transferred by
so-
deputy commissioner or preferred against the
yes.
judgment of customary courts in the so and so and so.
Now, this
Okay.
this part has to be read in two parts, Your Lordship.
This is the only area, according to you,
Yes,
which indicates and gives this choice to the to the litigants?
Yes,
This
Lord.
part only
yes,
this
yes,
part.
only this part, Your
It
Lordship.
should have been more explicit, actually, where, regarding the choice.
Yes,
So otherwise, if you on a plain looking, it looks like this,
yes,
which the court has interpreted. On a plain reading, it looks like that the village authority, the higher village council, and then civil court.
And also, Your Lordship, not particularly to this district,
Hmm.
there are many
Not maintainable.
villages, Your Lordship, which does not have an apex inter-village authority, Your Lordship.
Hmm.
This is not, this is something only basically to some particular tribes, Your Lordship. Not all the tribes in Arunachal have an customary court and then an apex court, Your Lordship.
Hmm.
Customary court is as per the local practices, it's recognized by all the clients, Your Lordship. But more particularly when it comes to apex inter-territorial customary court, Your Lordship, many of them does not have it, Your Lordship. So my contention, my submission before Your Lordship is that this particular amendment to section 15(3), Your Lordship, was overlooked by the Honorable Trial Court and has directly come to 15(4) and has made while dismissing my appeal, has come to a conclusion that it has to first go to the inter-village and then and if we are aggrieved, then come to the civil court. However, my argument on that is more basically on section 15(3).
This is a
Provide
slightly problematic area actually, because
Yeah.
as I said, the choice that we have understood, or
Yes.
you have understood, that the law gives a choice
Yes,
to the either to go to the mainstream
yes, Your Lordship.
civil courts
Yes.
or the customary courts. This should have been laid down more explicitly,
Absolutely,
more clearly,
absolutely, Your Lordship.
that an appeal shall lie at the instance either to this or that. It should have been. Now we have to derive that from
Only this particular,
interpretation.
Interpretation.
It may lead to errors
yes, Your
and litigation.
Yes.
Anyway,
So, Your Lordship, this act in fact has many loopholes, Your Lordship. More particularly even to the appeal proviso, and also Your Lordship will see this act does not even contain the scope of second appeal, Your Lordship, which has also been challenged before this court in another case, Your Lordship.
there is no
There is
second
no
appeal.
second appeal, Your Lordship. So if that is to be considered,
Only one,
Your Lordship,
only one appeal.
yes, if that is to be considered, Your Lordship will see that if an appeal is made before by the order of customary court, because it specifically says 15(4) specifically says then appeal to the inter-village territorial, Your Lordship. So the first appeal happens in before the inter-village authority, Your Lordship. Now since there is no proviso for second appeal, Your Lordship, even considering that the civil court has the power, Your Lordship, the parties has to directly come before the High Court under revision provision, Your Lordship, not before the civil court. Now, if that is to be taken, no civil court will be dealing with any civil cases or under this act, Your Lordship.
Anyway, Jeannie,
Your Lordship,
Honourable
my
Counsel
small
for the-
prayer is for the stay of the issuance of notice and stay of the Kaba order as well as this impugned order, Your Lordship.
No, this has merged actually.
Yes.
So the last order, if we stay,
Yes.
that will serve your purpose.
Because the stay.
Any separate execution proceeding? No.
No, but then the impugned order is on dismissal, Your Lordship.
Yes, then that's last order.
Yes.
Just into which the Kaba order is merged.
Yes.
In a way. Anyway, so Mr. T. Gini, learned counsel for the petitioner. Full stop. The petitioner has invoked the jurisdiction of this court under Article 226 of the 227 of the Constitution of India, seeking interference with the order dated 5/5/2026 passed by the Court of the Learned Civil Judge Senior Division, West Siang District, in Civil Appeal number 24 of 2025. In the said appeal, the petitioner as appellant had challenged an order dated 12/6/2025 passed by Kibang with regard to certain allegations made by him. The petitioner is Jumbo lawyer, right?
Jumbo lawyer, Your Lordship.
By him against the respondent Jomkir Nasu. Full stop. The allegations included making defamatory remarks on social media. Full stop. The adjudication before a customary court found the allegations made by the petitioner to be false and he was imposed with certain punishments, such as fine, etc. Next paragraph. Agreed by the said decision of the KBA, the petitioner filed an appeal before the Court of the Learned Civil Judge Senior Division, which was registered as Civil Appeal number 24 of 2025. However, the learned civil judge dismissed the appeal as not maintainable on the ground that an appeal against an order passed by the village authority, like KEBA, would lie before the inter-village customary court rather than the court of the civil judge. Next paragraph. His Genie Learned Counsel has drawn attention to the relevant provisions of the Arunachal Pradesh Civil Codes Act, more specifically Section 15, and the amendments that the said Section 15 has undergone by the Amendment Act of 2022. The Learned Counsel draws attention to this will be the proviso, second proviso,
Second proviso.
to subsection 15(3), draws attention to the second proviso to section 15 within bracket 3 of the AP Civil Courts Act.
Your Lordship, Amendment Act, Your Lordship.
No, it was after insertion. What would be the proviso?
Proviso would be 15, the third proviso, because the second proviso was amended, Your Lordship.
15(3).
Your Lordship will see in the second proviso of subsection.
Yeah, 15(3) second proviso. It will be. The amended proviso reads as follows. I've marked this Amendment Act of 2022, page 2. I have marked it. You just reproduce here. The Learned Counsel submits that the law as it stands today gives a choice to the party to prefer an appeal before the appellate customary forum or to the conventional civil court, depending on territorial jurisdiction. And that to that extent, the learned appellate court has misread the provision and incorrectly held the appeal to be not maintainable. The Learned Counsel prays for staying the impugned judgment for the moment at least. Next paragraph. I have perused the materials prima facie and considered the submissions. Full stop. Issue notice upon the only one respondent,
Only
right?
one response.
Respondent, full stop. By speed post.
Yes.
Petitioner is at liberty to write that resort to justice service. In this case, affidavit compliance will be filed. Do we call for case record?
Case record, Your Lordship.
Call for the scan TCR of we call from the civil judge.
Civil judge, Your
Civil judge, and this also the Gauhati
the-
records will
the
also be
records-
necessary.
The records were in, the records was called from the Gauhati.
Also, because it may have part of it may have gone back. Call
Yes.
for the scan TCR of civil appeal number so and so from the Court of the Learned Civil Judge Senior Division. Also call for the scan case record. You write just case record, scan case record of Will, from the village authority, what will be the number of the matter?
There is no numbering of the case, Your Lordship.
Will they be able to send it? Will they be able to send the record? You're not
I'm not sure,
doubtful.
but because during the appeal, when appeal was heard, Your Lordship, the record was called from the village authority and it was produced, Your Lordship.
Also call for the case record from the
Head Gambura, Your Lordship, Logum Jini.
from the concerned customary authority, namely the head Gauhati
Logum Jini, Your Lordship.
village, Logung Jini village,
West Siang District, Alo.
Iskiang String Alo. Yes. Next paragraph. Upon giving my consideration to the prayer for stay, it is directed that till the returnable date, the impugned judgment and order dated 5/5/2026 passed by the learned Civil Judge Senior Division in Civil Appeal 24 shall remain dismissing the appeal against order dated 12/6/2025 by Gambura so and so dash shall remain stay. List after 3 weeks.
Different.
Item number 4.
May I please, my lord? My lord, here challenging the legality and validity of the impugned judgment and order dated 11 July 26 passed by one head Gambura of Ded Rake village, Kampo Region Circle of Kamle district, my lord. My lord, lordship may come to page number 15, my lord. Annexure 1, impugned judgment and order, my lord. Page 15, my lord, may I read out?
You're coming straight away against the order of the Gambura.
Yes, my lord, this Gambura, he has no any jurisdiction to pass this judgment and order, my lord. And in fact, there was 11/7/2026, there was no such kind of local customary court was conducted, the mail, my lord, meeting.
Page
Page 15, my lord.
15.
15, my lord, 1/5.
1/5. I'm on 1/5 only.
May I read, my lord?
Hmm.
Whereas on the 6th of July 26, the learned Deputy Commissioner Karadade District, Palin issued a verbal order to mutually settle the dispute between Yom Buli Welfare Society, here in the respondent number 2, my lord, and Bania Welfare Society petitioner, pertaining to serial number 737 in respect of 16.8 hectares regarding the payment of compensation by NHPC for Kamle Hydroelectric Power Project 1720 megawatt. And whereas the president of the Yom Buli Welfare Society initiated effort to mutually settle the dispute and issue a circular dated 8/7/26. Consequently, on 11 of July 26, a joint meeting, Yom Buli Welfare Society and Bania Welfare Society was convened at Abasa Hotel and Family Restaurant at Dilo Palyang, Hapoli. Hapoli is a minor Lord Sovereignty district. The proceeding was presided over by Sri Tayo Tasar, head GD, Ded Rake, acting as judge. They were assisted by representatives of both the parties, Sri Tayo Tajum, intellectual, and Sri Yende Tham, representative of the Bania Welfare Society. After hearing both the parties and conducting a prolonged discussion on their claims and available witnesses, following was observed. There was no material evidence presented by the Bania Welfare Society as they failed to produce reliable proof to show that the land in question belonged to them. In contrast, the Yom Buli Welfare Society produced a reliable and trustworthy witness, the causing evidence to support their claims. Influencer. Taking this observation into consideration, it is evident that the disputed land belonged to the Yom Buli Welfare Society. With this order, the case is disposed of. My lord, now the my lord, lordship, I'll take to page number, my lord, 23, my lord, circular notice issued by the respondent number 2. This is Yom Buli Welfare Society. Page number 23, my lord.
23.
Yes, 23, my lord. Notice of discussion. Heading is written as notice of discussion. Page 23, my lord. 1-3.
Notice of discussion.
Yes, my lord. Notice of discussion. Dated 8/7/26, which refer in the judgment given by the government. Continuation of the hearing commenced by the Deputy Commissioner Karadadi District Arunachal Pradesh on 6 July 26 regarding 1720 megawatt Kamle Hydroelectric Power Project. It was discussed that certain portion of Yom Buli area had been mistakenly marked with Karadadi District. During hearing, the executive members of the Yom Buli Welfare Society, Kamle district lead by Moses Yom Nigla, the president so and so, presented the society matters and clarified its positions before the deputy commissioner and official present. However, Sri Bania Taba and Sri Dem Tarang objected to the statement of the Yom Buli Welfare Society and claimed that there's some portion of land claimed by YBWS belonged to this Bania Society. In view of the controversy, the deputy commissioner directed both YBWS and the Bania Society to again appear again on 13 or 14 July 26 for further hearing. Therefore, Sri Bania Taba and Sri Dem Tarang are hereby requested to attend and discussion prior to the scheduled hearing. Date venue is given Abasa Restaurant Hapoli, my lord, and 11 July 26, time so and so. And this was heading to the president of this petitioner number 1, my lord. So, my lord, this was the kind of minute of meeting called by the respondent number 2, my lord. So, there was no such kind of local customary court was conducted. So, this Gauhati who is purportedly passing impugn judgment order, my lord, he was accompanied with the respondent number 2, 3, and 4, my lord, in that meeting. So, after discussion in this meeting, petitioner was also present there, and this private respondent number 2, 3, and 4 was present. However, my lord, there was no any outcome was took place in the meeting, in minor the meeting. There was manhandle from the side of the respondent, my lord, private respondent. Consequently, my lord, this petitioner has compelled to launch FIR before 0 police station, my lord. Page number 24 is, my lord, FIR.
No, on this notice was given on 8/7/26.
Yes, my lord, 8/7.
Fixing it on 11 July.
11 July, my lord.
On 11 July, what happened?
Yes, that's why, my lord, 11 July, Gauhati has purportedly passing judgment and order, my lord. There was a settlement arrived between the parties. In fact, my lord, no such kind of settlements were arrived between the parties, my lord. There was manhandle from the side of the private respondent.
No, you are assailing this order, right?
Yes, my lord.
Don't you have to exercise the right of appeal to the inter-district
My lord,
customary
this
court?
Gauhati, he have no any authority to have meeting on in regard, because, my lord, plot of land which disputed is it falls under the lyric village of Tarak Lengdi circle of Kurungkame district, my lord. So the Karadadi district, my lord. And Gauhraj belong from the Kamle district, my lord. He was just to witness the process in the meeting.
He is the Gauhati of Kampo.
Did Rakhe village of Kamporijo circle.
Did Rakhe
Yes,
Rakhe
Kamle
village.
district, my lord. He has no any authority, my lord. Even, my lord, this circular was not issued from the office of the Gauhati, my lord. The notice was issued.
And the land in question falls in?
Question is Karadadi district, my lord. That is in Tarak Lengdi, Go-Rijo area in Tarak Lengdi circle of Karadadi district, my lord. Which disputed land is
Disputed land is, I'll just write it down.
my lord.
Disputed land in, can you give me the spelling of that
My lord,
district? Kara,
Lyrik, lyric, Lyrik, lyric village,
Lyric village in
Tarak Langdi, Tarak, Tarak, Langdi, Langdi circle of Karadadi district.
Karara.
Kara, Kara,
K-R-A,
Adi, my lord.
K-R-A.
D-double-A-D-I, Dadi Karadadi district, where land is situated, my lord. And in fact, the complaint which I made before the deputy commissioner Karadadi district is still pending, my lord. So, my lord, consequently, on 11 July, there was no such kind of judgment and meeting was conducted and no any.
Both the societies belong to different areas.
My lord, different village. I am from Karadadi district, and this respondent number 2 is Yom Buli society is from Kamle district, my lord. So
Kamle
yes,
district.
they have invited us to have a meeting, my lord, just for mutual.
Kamle district.
Yes, my lord. So suddenly we came to know that this Gauhati has purportedly passing this judgment order. We were very much shocked and surprised, my lord. So consequently, we have also launched complaint before, my lord, Deputy Commissioner Kamle district on 17/7, my lord, page number 31, my lord. 17/7/26, we have made representation in against the Gauhati who has purportedly passing judgment, my lord. So strict action has to be taken, as he has misused his power and position as a Gauhati of the concerned village. So we have also launched complaint. Subsequently, we also launched complaint before the Deputy Commissioner Karadadi district, my lord. That is in page number, my lord. My lord, may find in page number 34. Is complaint made before the Deputy Commissioner Karadadi district. And my lord, in fact, we have already launched complaint before our concerned Gauhati where the disputed land is situated, my lord. That is in page number 36, my lord. We have also made complaint before the head Gauhati of Kambang Riambang village, which land is situated, my lord, for amicable settlement. So supposed to issue the notice and all. This respondent number 2 has invited, 2-3 has invited us, and we went there, but there was manhandling from the side of the private respondent, my lord. So consequently, we were compelled to launch FIR also, my lord, before Zero police station. FIR is in page number 24, my lord. So, my lord, this impugn judgment and order, which was completely biasness, and he has completely, without any jurisdiction, passing judgment and order, there was no such kind of the decision was took place, my lord. So, my humble prayer, my lord, notice may be issued, my lord, to the respondent, private respondent, until then, my lord, this impugn judgment and order dated 11 July 24 may be stayed.
Have you stated that you belong to two different districts?
Yes, my lord, I have clear and mentioned in my petition, my lord, somewhere. Because they are different place, different district, my lord. And this Gabra is also from Kamle district, my lord. In fact, my lord, police has also we have made complaint before the police station or before the commissioner, my lord. That is our complaint is page number 16, my lord. Lordship may allow, may read out the page number 16. Yes, this is our complaint before the police station, Karada, Palin police station, Karada, the page number 16, my lord. So in this regard, police has also made inquiry upon the encroachment of the land. Just the last paragraph, my lord. I just said page number 17, my lord. Second, that it is humbly submitted that the destruction caused at the site has caused the clan members much distress, financial loss, and has disturbed the peace and security of the clan members. It is humbly submitted that their action amount to criminal trespass, theft, mischief, and property destruction. We therefore request you to take appropriate legal action against the aforesaid accused person, investigate the matter, and register the case under relevant section of law, including section so and so. This is, my lord, which we made complaint before the police and also the deputy commissioner. So, my lord, police has carried out the investigation, my lord. My lord, police inquiry is page number, starting from page number 18, my lord. And it's a 3 month. My lord, police inquiry is operative portion, lordship may find in page number 19.
So basic contention is that the territorial jurisdiction is not there.
Not there, my lord. In fact, the meeting was conducted at 0, my lord, Lord Shavansari district at Avasa Hotel Restaurant, my lord. So there was a simple minor meeting invited by the private respondent, my lord. And accordingly, we on good faith went there, but there was no such solution has been made, resolved, no any the decision was taken place. However, they have started the physical assault. So we left the meeting, and thereafter we launched complaint FR before the 0 police station.
Third, learned counsel for the petition, who has invoked Article 227 of the Constitution of India to assail a judgment and order dated 11/7/2026, passed by the Head Gambura within bracket HGB of Dibrakhe village of Kamporijo circle of Kamle district as customary court. Next paragraph. The dispute was with regard to a land between the petitioner number 1, namely Bania Welfare Society, and the petitioner and the petitioner respondent number 2,
Yes.
Yom Buli Welfare Society.
Yes.
Full stop. The matter was initially taken before the deputy commissioner, and the deputy commissioner was pleased to issue a verbal order to verbal. It was the DC addressed the order to the Gambura.
Yes, my lord. No, my lord, not society member, my lord. Private
To
respondent.
the verbally instructed the members of the two societies
Yes.
to amicably settle the matter. Subsequently, A meeting was stated to have been held on 11/7/2026 before the SGB of Didrake, Mr. Tayo Bastasar, and he passed an order holding that the disputed land belongs to the Yambuli Welfare Society, within bracket, YBWS. Full stop. The learned counsel submits that while the petitioner number 1, being Bania Welfare Society, belongs to the district of Kradadi in the state, the respondent number 2, Yambuli Welfare Society, belongs to the district of Kamle. The land is situated where?
Land is situated at in my circle, Tarak Langdi circle. Lyric,
In the Dadi district,
yes, Karadari district.
Karare district. It is also
Police report is.
submitted that the purported disputed land lies in the district of Kradadi.
Karadari.
Also Karadadi. Full stop. In support of this contention, the learned counsel for the petitioner draws attention of this court to a police report dated.
Police report, my lord.
You have mentioned in the para,
15/11/25. 15/11.
police report dated 15/11/2025. Have you annexed
Yes, my lord, I have
the
an
page?
from page number, my lord.
Okay, being annexed as
Cooperative is page number 19.
Annexer 3. Full stop. The learned counsel has also drawn attention of this court to the narration to the statements in para 5 of the revision petition,
Yes, my lord.
and that the lands are situated in Lyric, L-E-Y,
Lyric,
Lyric village under Tarak Lengdi of Karadadi district. Full stop. Next paragraph. In the context of the above, the learned counsel submits that the impugn order was passed by an authority devoid of jurisdiction and therefore may be interfered with. Next paragraph. At this stage, the petitioner side shall take steps of notice upon the respondents. Extra copies be furnished to the government advocate representing this respondent number 1/state. Notices upon 2, 3, and 4 by speed post. The petitioners are at liberty to resort to dusty service, in which case compliance affidavits shall be filed. Are also at liberty to file the resort to dusty service, in which case compliance affidavit will be filed. Full stop. The next, upon giving my anxious consideration to the prayer for stay, I deem it appropriate to stay the impugned order till the returnable date for the moment. Accordingly, the impugned order dated so and so passed by the Gaubura, we have mentioned, shall remain stayed till the returnable date. Next paragraph. Needless to say that as the interim order has been passed ex parte, the respondents upon their appearance shall be at liberty to seek
yes.
modification, variation of the same.
Yes.
List after 3 weeks.
My lord, this matter that they are residing in the far flung area, so some time may be given. Private respondent.
Yes.
Nowadays, road is communication from not.
4 weeks, 3 weeks, 3 weeks.
Take.
Matter number 5,
It is under 528 for quashing of FIRs.
Mhm.
FIR dated 30/6/2026. Herein, the petitioner number 2, the complainant, had lodged one FIR before Itanagar Women Police Station, stating that the petitioner number 1 has molested and sexually harassed her at her workplace, which is at Ganga Market, Itanagar. So consequently, a case was registered being numbered as Ita Women PS case number 57 of 26, and the matter is presently under investigation. My lord, in the meantime, what has happened, this party, after intervention from the family, they have, since the matter, there was some minor misunderstanding as well as this thing has happened out of
Mutual settlement is there.
yes, my lord. Settlement agreement is at annex 3, page number 27. Page number 27. First party is the complainant. Petitioner number 2 in this
Okay. Yes, madam. What do you say?
Lordship,
We call for the scan.
yes, Lordship.
Case diary.
Yes, Lordship. And moreover, Lordship, here,
But-
Lordship, the victim, Lordship, they have already settled, Lordship.
That's
Then
what-
it would be a
Should we stay the investigation?
less, Lordship, because it's futile access, Lordship, because in trial also, Lordship, if no one will be, Lordship,
Hmm.
there
No,
to,
no,
Lordship.
that's true. But the thing is that at this stage, we'll have to issue notice.
Yes, Lordship, definitely, Lordship.
Notice. Actually, as you know, the standard of staying investigation is very high.
Lordship. Yes,
You look up Niharika infrastructure, that case, since standard is very high, that's one. In certain special circumstances, sometimes it can be stayed. The second point is that as far as interim relief by way of coercive action and all these things are concerned, it has been indicated in the judgment that that kind of relief should be ideally given in a petition for anticipatory bail,
yes, Lordship.
right? Either you stay
Yes,
the
Lordship.
investigation or you don't stay the investigation.
If
As
they
far
have
as-
the
Huh?
apprehension, then can they file for
Yeah,
the IO,
yeah.
this AB also?
Yeah,
Lordship?
either you stay the investigation or you don't stay the investigation.
Yes, ma'am.
The threshold is high. That's
Yes.
one aspect. The other aspect is that instead of passing a no coercive action order in a quashing petition, the Apex Court in the judgment has indicated that if such relief is necessary, a separate anticipatory bail, there you can
Yes,
grant
yes,
full
Lordship.
bail,
Yes, Lordship.
right? This is better. Anyway, but still, it is not barred. Coercive action order can be, but that is the encouraged route. You get my point?
Let's go
That's
for
the
the
encouraged
case,
route.
yes, Lordship.
So it can be passed. It's not that it has not been said that you cannot pass as an order, but that is the encouraged route. In case of a settlement, of course, things are a little different. So shall we pass an order of no restraint coercive action and allow the investigation to continue or stay the investigation itself?
Lordship, I will call for the case study, Lordship.
Hmm.
After that, we'll.
Coercive
see,
action,
Lordship. Yes,
that
Lordship.
we can
Only
pass
coercive
here.
action, yes.
Because why this has been done actually is that in matters of investigation, time is very crucial
Yes, Lordship.
because collection of evidence,
If there's nothing.
time is very important. Suppose you collect some evidence today, after 10 days that evidence may not be available. So therefore, usually investigation is not stayed.
Yes, Lordship.
That is the reason. But of course, settlement is there.
Hmm.
Heard learned counsel for the petitioner, and he learned counsel for the learned additional PP for the state. Both the petitioners have joined over.
yes, we filed this.
The accused petitioner, the petitioner number 1 and the petitioner number 2. Petitioner number 1 within bracket accused and petitioner number 2 / informant within bracket informant have jointly filed this petition invoking section 528 BNSS seeking quashing of Itanagar Women PS case number 57 of 2026 under so and so section. an FIR dated 18, the case arose out of an FIR dated 36/2026 lodged by the petitioner number 2 with certain allegations against the petitioner number 1. And thereupon the aforementioned case was registered. Next paragraph. It is stated and submitted that in the meantime, the parties, with the help of their family members, arrived at a settlement which was incorporated into a mutual settlement deed dated 18/7/2026, stating that they have amicably settled the dispute and that informant does not want to proceed with the case. In this backdrop, the quashing petition has been filed. The learned counsel also seeks an interim order of stay. The learned additional PP submits that the scan case diary may nevertheless be called. Accordingly, call for the scan case diary of Itanagar so and so.
Yes, that's
Also, considering the fact that the parties have arrived at a settlement and have jointly filed this quashing petition, it is directed that till the returnable date, the petitioner number 1 shall not be subjected to any coercive action with regard to the aforementioned PS case. Leave the matter after 2 weeks. How much time will you leave?
Yes, Lordship, after a week also, Lordship, because Itanagar PS is nearby, Lordship.
After
After a week, Lordship.
2 weeks.
Lordship,
It can be earlier also.
yes,
It's
Lordship.
okay. After 2 weeks.
I like.
Take a short break. No?
Number 8.
Lordship, this is a LA appeal, Lordship.
Before that,
I'm being aggrieved.
Yes.
They have filed one KB.
caveat is there, before that caveat
Can
maybe.
be discharged
No. You have filed a caveat
Yes.
on behalf of
private respondents.
private respondents.
4-2. Kita.
Caveat 88, madam.
Uh, 3-2, private respondents are 3-9.
Yes.
3-9. The award was under the 2013 Act,
Yes.
2013 Act.
Yes.
The reference code, you are seeking enhancement of the same?
No, Lordship. There, in the reference petition we have filed,
Mhm.
the appellant we have filed
Right. Against
for deciding on apportionment
apportionment.
under section 64. Now, the private respondents, they have filed one miscase,
Mm.
raising certain maintainability of the case before the reference court. Accordingly, that miscase was heard and entire reference case itself was dismissed. So I'm being aggrieved by that
Dismissal of the reference case.
dismissal of reference cases. Lordship will find that impugn order, which I have impugned in.
We'll examine it. We'll examine the appeal. Yes. We'll admit the appeal.
Yes.
And we'll call for the records.
Lordship, I have an interim prayer to make.
Madam, interim, it would be difficult, madam. The compensation has already been disbursed, madam.
So why, Lordship? That is one of the
Then
issue here, Lordship.
the complication that would arise, madam, thereafter so many people, after disbursement, madam, the staying of the order, your lordship is aware. It will raise more complications. If he's successful, definitely, madam, he will get the amount.
You
Recovery.
file an IA then separate IA can be filed. We can hear on that.
Yes.
Hear on the aspect of stay.
Section 77, Lordship, may kindly take up. Section 77,
On the
subclause 2 talks about when the reference is pending before the reference authority, the deputy commissioner is mandated to deposit the amount before the reference court, Lordship. In fact, we have approached the deputy commissioner as well as the learned court reference authority for direction to submit, to deposit that amount. That also not done, Lordship.
Where page 77 provided that section 77
Subclause 2.
subclause 2. You can read it. The person entitled.
If the person entitled to compensation shall not consent or received, or if there be no person competent to alienate the land, or if there be any dispute, this is important. If there be any dispute as to the title or receive the compensation, or as to the apportionment of it, the collector shall, the word used is shall deposit the amount of the compensation in the authority to which a reference under section 64 would be submitted, Lordship. Now, under this section, Lordship, 7 subclause 2.
During the pendency, it has to be deposited.
Yes.
During the pendency. Obviously, there's a
Lordship,
dispute.
when this matter was pending before the reference court, the deputy commissioner did not submit that, deposit that amount.
Because you file an IA for the stay and we'll hear on the
Yes.
aspect of stay.
That can be done.
You file it immediately.
Yes.
And then you will hear on the aspect of stay after they appear. And then we can
Lordship,
take a
if
call.
they are
Instead of
saying,
straight away
we are
saying
not
it-
aware, Lordship.
No,
If they are saying that the compensation amount has been dispersed, proper instruction is required, Lordship.
No, take instruction.
Let them take instruction within 2 days. I'll file the additional affidavit upon their instruction, Lordship.
That can be done. Yes.
IA will be
Instruction
filed.
is not required. I have the copy, man.
You have the call.
Now, where the amount has been deposited,
No, they will also take
to
instruction.
whose account it has been deposited, and who the bank account, in which bank it is operating, all those information is required, Lordship. So that they can also be made as a party, Lordship, in my IA, Lordship.
Lordship, I'll ask to check, Lordship, Miss Khan.
Hmm?
Check. It's already been dispersed.
Yeah.
Okay. Where is the impugn or judgment?
Lordship, page 1014, Lordship. 1014.
1014.
Correct, Lordship.
Because it does not have all these pages. 400,
Lordship,
500. There's another compilation.
Can compare.
दो compilation.
It has to be examined actually, the prima facie. 1014.
1014.
It'll take considerable time, Maharaj.
Yes. Because
On-
without
On
straight-
2 grounds, the learned reference court has decided the entire matter, Lordship. I have a very good case, Lordship, in fact. The judgment that I have relied, Lordship, that was not considered. And certain aspect of section 64 or 37, 21 of LAR Act was not considered, Lordship.
Yes, notification, yeah. Okay. Original part. Immediately I apply करो बैंक पार्टी बना के SBI को becomes yeah. What order करने लगा
Anyway. We'll have to examine the matter. Yes, we have to. Heard Mr. Learned Counsel for the appellants. How many appellants have joined? 24. 24 in number. Who have assailed the judgment and order dated 24/7/2026 passed by the learned district judge Lohit at Teju in his capacity as land acquisition, rehabilitation and resettlement within bracket LARR authority under the right to fair compensation that RFCT LARR Act 2013 from the cost title. Right. Full stop. Next paragraph. By the said impugn order, the learned district judge adjudicating the reference proceeding being reference case number 3 of 2023 dismissed the claim of the petitioners, holding that their lands were not subject of acquisition. Holding that the lands claimed by them were not subject of the acquisition proceeding, semicolon, that the reference was barred by the limitation. Full stop. Nine respondents, next paragraph, 9 respondents have been impleaded, out of which respondent number 3 to 9 are private respondents. A caveat has been filed on behalf of the private respondents, being caveat number
89.
89 of 2026. Learned Counsel appears on behalf of the caveators, and accordingly the caveat being caveat number 19 the caveat number 89 of 2026 stands discharged. Full stop. It is the Learned Counsel, next paragraph. The Learned Counsel's praise for stay of the impugn judgment and order, comma, to which the Learned Counsel for the private respondents submits his objection and further contains that disbursement of compensation has already started and any stay would jeopardize the situation. Full stop. The Learned Counsel for the appellant submits that in this context, perhaps the learned government advocate representing the state respondents can take instructions. You can take.
My instructions are also same. It has already been disbursed.
Full stop. Should I record that? Full stop?
Yes.
In this context, Mr. Apang, Learned Government Additional Advocate General submits that he has also been informed that disbursement of the compensation is going on.
Has been done.
Has been done already. Full stop. So if we adjudicate the matter, what can be done? They can submit an indemnity bond or something?
Ultimately, lastly, civil court
Will decide.
go to civil.
But then, Lordship, during the pendency of the case, Lordship, in such case, Lordship, there has to be a freezing of the account also, Lordship. That part will come in the IA, Lordship, since we have got certain documents today.
On the aspect of stay of the impugn judgment, the Learned Counsel for the appellants submits that he may file a separate interlocutory application to agitate his grounds for stay pending disposal of the appeal. First. We'll admit the appeal in the meantime. You can add. Upon considering that the matter projected by the appellants might require examination, the instant appeal under section 74 of the RCTCR Act is admitted for hearing. Extra copies shall be furnished to the state respondents, being respondent number 1 and 2. Steps of notice shall also be taken upon respondent number 3 to 9. How will you take? Very voluminous.
Already he has
Received. Learned counsel accepts notice on behalf of respondent number 3. That will, makes your job a little easy because it is very voluminous. 3 to 9. Full stop. So we'll examine. You file this thing.
I'll file the.
So in case some order on those lines have to be passed, you may have to file an inability bond.
To the IA, definitely we will file objection.
Yes. You file the IA, and suppose this thing that formal stay is not granted, you may have to file submit indemnity bond, depending on the subject to the outcome of this.
Record may be called.
Yes, records have to be called for, of course. We'll call for the original records.
Yes.
Original. It's disposed of. We'll call for the original records of LA number. So we mention Ejo in the top. LA case, reference case number 3 of 2023.
2023.
From the court of the learned district judge, within bracket LARR, Lohit district at Teju. That's all.
Yes.
Take the date. Take the date. List after. How long?
We have 4 weeks, madam.
4 weeks.
In the meantime, I'll be fine with IA.
List after 4 weeks on a date to be fixed by registry.
Yes. Much.
Right.
Item number 9.
Meet, please, your lordships.
Just a minute. Please keep this also.
That I am appearing through VC Mlad.
Yes. Okay.
But in fact, I wanted to come personally for some other cases fixed, but I could not. The petition.
This is for quashing.
Yes. But it has got a checkered history, Lord. I'll take your lordships. To the FIR, if you lordship kindly have page 76.
Which?
Already the contents are there at page 79, if your lordships kindly have it.
9 will be convenient.
Yes.
Fire. Go ahead.
My lord. Subject, name of the complainant. My lord, kindly take note of the name, Mr. Tayo Talom Rending, proprietor of Mrs. Tayo Enterprise. And name of the accused, your lordship, kindly have a look. First one is Mr. Toluk Lombi. He is based at Itanagar, Naharlagun. Second one, who is the petitioner herein, one Mr. Rakesh Kumar Singh, based at Gauhati. Third, your lordship would see Mrs. Dubi Ete. She is also based at Naharlagun. So, for your lordships, I just read the FIR, it would be relevant. So
okay.
I beg.
We can read. No. Go ahead.
I beg to inform you that I am a registered class 1 contractor of the state of Arunachal Pradesh, executed various construction work of RWD under PMGIS, PWD and UD Housing Department of Arunachal Pradesh The accused number 1 is also a contractor and proprietor of Mrs. DTL Ventures Naharlagun, Arunachal Pradesh, who came to know that I have pending bills at Rural Work Department for execution of the following works. But these two works are given, Millard. The value of outstanding pending dues is 17 crore 90 lakhs. The accused number 1 hatched a criminal conspiracy in connivance with accused number 2 and 3. Here my name comes, Millard. Approached me in my office at Naharlagun that he has good link in the department. He has good link, Millard, and also having good relation with the political leader of this area in the present government of Arunachal Pradesh. The accused number 1 and 3, Millard, I am not there, your lordship would kindly mark, told me that the accused number 1 had a good link in the Ministry of Rural Development, Government of India, and they will get the sanction order for aforesaid pending bills against the work done by me within December 2024. The accused person asked rupees 2 crore 40 lakhs odd for their to and for expenses to get the sanction order from the government on 16/9/24. I paid rupees 1 crore 39 lakhs from my account located at Naharlagun Bank of Baroda to accused number 1, Mr. Taluk Lombi, informed so and so. Account number so and so. After payment of the aforesaid amount, the accused person came to my office on 7/12/24 with a letter bearing number so and so issued by one Rajesh Bhardwaj to Government of Arunachal Pradesh allocation of fund under PMG Rural so and so about 29 crore 37 lakhs 32,000 against my firm Mrs. Tayo Enterprise purportedly showing sanction of rupees 15 crore 46 lakhs. After going through the letter, I got doubt about the authenticity of the letter mentioned above. They told me it's sent through WhatsApp from Delhi. I need to pay again rupees 1 crore 1,26,000 only as part of final payment. The accused number 1 himself is a registered contractor and accused number 3 is a local lady. On good faith, I paid the aforesaid amount to them on 30/3/2025 and they assured that government release the amount very soon. I went to the office of the chief engineer to inquiry about the allocation of fund and also the authenticity of the letter mentioned above. The chief engineer RWD informed that no such letter received and it was a fake manufactured and fabricated document. It is a designed criminal conspiracy and impersonation act of the accused. I called the accused number 1 to return my money which was fraudulently taken by them. Then the accused number 1 told me that the accused number 2 has done this conspiracy. But only I am named here. Lordship would see that the accused number 1 is blaming me, who is a habitual owner. All the accused person has shared the aforesaid amount. I therefore request you kindly register a case under the appropriate section of law against the accused person and recover my money. I further looking forward for your consideration and necessary action. My lord, kindly have a look at the date of the FIR. It is dated 5/9/2025. It has got relevance. Why I say so, my lord? The petitioner herein, the accused number 2, had a business dealings with all these 3 persons, my lords. The informant, the other accused, Mr. Tayo Talom and my lord Toluk Lombi, as well as Dubi Ete. Now, what happens, my lord? Milord, there has been some business dealings between them, Milord, that we have stated in my petition, Milord. And I'll straight away take your lordship to page 21.
Just a minute. Page 21.
Yes, yes.
Yes.
Milord, this is an agreement, if your lordship would see, dated 49/24. It's more
Between?
than a year, 49/2024. It's a
Informant.
notary registered, my lord.
Between informant and the accused petitioner.
Yes, yes, yes. This is a general power of attorney. By this means I, Tayo Talam Rending so and so, your lordship would see that he has given me the power of attorney to operate his firm. Milord, that kind of relationship we shared, Milord, so far as informant is concerned. Now your lordship would kindly come to page 26. And before that, your lordship would also see page 25, Milord, part of the first agreement.
25.
Yes.
Okay.
This is the schedule. In the schedule, he has authorized me to operate his firm as well as his account numbers, my lord. If I have to do any mischief, I could have done that way, my lord. Now your lordship would also see
He
at
was
page
the petitioner was the power of attorney holder of the informant
informant. Yes, my lord.
at one point of
Then
time.
at page 27, my lord, he has authorized me to operate his vehicle, my lord, one Mercedes Benz, which I am still operating. Now, so far as the other accused, Mr. Tayo Toluk Lombu is concerned, my lord, your lordships kindly come to page 29.
Yeah. 29. Yes.
Yes, there is a memorandum of understanding that has been executed, my lord, between NC Banerjee, my lord. One work we have been allotted to him at the instance of the petitioner herein, my lord. And he's been doing this work at Shillong, my lord. We have given the type copy of that. Now what happens, my lord? There is one further work, my lord, which the informant has obtained at Karimganj.
Okay.
My lord, kindly have a look at para 4 of my petition that I've indicated, lordship.
Para 4.
Yes. That the petitioner number 1 states that he is based at Gauhati and through one Dubi Iti, who is a businessman woman and permanent resident of Arunachal Pradesh, came in contact with the informant. The petitioner developed business transactions with the informant and he had negotiated a big contract in Karimganj district of Assam for the respondent number 2 informant from one Mrs. MKC Infrastructure Limited based in Ahmedabad, for which the petitioner and Ms. Dubey are jointly entitled to get a commission to the tune of 11 crores. Milord, this is only a commission amount. The work contract is about 550 crores, milords. It's a NHI contract, milord. Informant had made some payment to the petitioner in respect of the aforesaid business deal. So, milord, some payment has also been made by the informant to them. In this context, it is relevant to mention herein that the respondent number 2 informant had executed a general power. Now, my lord, this general power of attorney, my lord, I have given to your lordships. This is the background under which he has given us to use his business as well as his vehicle, my lord. Now, what happens, my lords, in respect of the, my lord, business transactions, the Miss Dubi Iti and me also had some transactions based on which some payments have also been exchanged between us. And that details we have given in our bank account also, my lord. And the entire payment, so far as this transaction are concerned, my lord, has been made to the account of Toluk Lombi. And part of the payment was made to Miss Dobi Eti. And what has happened? When the work could not be done, my lord has seen the kind of work it is. It per se is an illegal work which they want to do it in an illegal manner, and once it's not been done, now accusation has been made. And I have been made a soft target because of the reason what has happened is, my lord, we have given a joint acknowledgement at page 53. If your lordship kindly have a look at it. And your lordship would also see the date on which it has been given. It is dated 10/7/2025, my lord, prior to almost 2 months prior to the lodging of FIR. We, Rakesh Kumar Singh, so and Ms. Dubey Eti, do hereby acknowledge the receipt of amount of 2 crore 40 lakhs on transfer Mr. So-and-so. The amount was transferred so-and-so. We further declare Ms. Lombi has no role in the matter. Therefore, we do undertake the full responsibility of the aforesaid amount. And 7, we actually adjusted against the due of 11 crore that is to be payable, your honor, lordships. So what has happened that Miss Dubi Eti has informed that this gentleman is after her, and since we owe money from him, so we give an undertaking to the effect that if some money is payable, we will adjust that amount, my lord. Now, after this, my lord, he files this FIR your lordship has seen. And only, my lord, because I have given this acknowledgement, my name has been dragged into it. And this would be further proved by the settlement deed at page 56, your lordship would see. The story becomes further interesting, my lord. My lord, after lodging of the FIR,
Is he on bail in this case?
my lord, not bail, my lord. Your lordship has been pleased to grant an interim order that further no coercive measures should be taken against him. My lord, in fact, I had the occasion to hear your lordship's view, my lord, in the earlier case, my lord, when your lordship has seen that in what conditions a stay order can be passed and as well as the no coercive measures. My lord, the
My view,
settlement,
actually, near infrastructure. Anyway, so this was there.
yes.
So we'll have to see, let us call for the case diary at this stage. What do you say?
We do have, my lord.
You already have the
Yes,
case
my
diary.
lord. My lord,
Yes,
here,
my lord,
my
that
lord,
would
the-
also give a very interesting picture, my lord. What happens now, my lord? On 14, the lordships, they lodge this FIR. This is registered on that day, but this gentleman is called in police station, Mr. Toluk Lombi, as well as the lady in police station Naharlagun. And they are kept in custody entire night. They are not shown arrested. That the informant comes, he comes with this agreement, and your lordship kindly see the settlement deed at page 56. Page 56, my lords, next chapter. This
Yes.
deed of settlement is made on 14th September 25 at the office of Toyo. Lord, it was done as police station, my lord, in between so and so and so and so. Whereas Sri Tayo rendering interest, the background is there. And where for the said retrieve pending bills, Sri Tayo had paid rupees so and so to Toluk Lombi. Lord, here there is only reference of Mr. Toyuk Lombi. Nothing has to do with petitioner respondent number 2. And whereas during the time of payment so and so, everything has been mentioned here. Now, lordship would see at page 57, this settlement is made threadbare discussion between both the parties, including family members as well as well-wisher. Now, both the parties have considered agreed under the following terms and conditions. That the first party has promised and assured that he will return the said money with lump sum interest along with principal grant, total amounting to 4 crores, with 5 months from the date of execution of this settlement. That as per this deed of settlement, so and so, my lord will see a relative of Mr. Lombi, Dr. Luxi Jilen, who happened to be sister-in-law, stand as security holder for the first party, and he voluntarily mortgaged his plot of land along with building located at Transport Colony. The details has been given. So what is done, my lord? An agreement is executed at police station, forcing the other accused, my lord, to enter into this agreement. And the objective and purpose is this: if my payment is done, I will withdraw this FIR. So this has nothing to do with me. Now, your lordship has seen from the FIR, if even at all there is allegations, it's allegation against them, and police does nothing, my lord. Therefore, the case diary would reveal, my lord, how they have come forward. Now, what happens, my lords? After this deed is signed, my lord, they have not been arrested. And one fine day in 31st of December 2025, both the other accused with police from Naharlagun comes to my place. They have issued me notice at the 35B, but they have returned back to them. I have no occasion of being aware about this FIR. And then, my lord, further interesting thing happens. These two gentlemen forced me, the lady and the gentleman. I had no option. Police is at Gauhati, my lord, after me. Then comes that settlement of 4th, my lord, that I have to execute one settlement on 3rd of January 2026. That your lordships find at page 70. Both the other accused are there, my lord. And after narrating entire facts, my lord, the lordship sees that
Just
they
a minute.
want, my lord,
Just a minute.
my lord.
Okay.
But not only me, my lord, I have to also arrange for a guarantor, my lord. I have to call for a friend of mine who also had to give a guarantee of further 4 crores. We had given post-dated check, my lord. We had no other option, my lord.
So I've understood, like, let me see, come to you with the case diary, you can submit.
May I, my lord?
Mm.
May it please your lordship. Your lordship,
I'll come back to you for a reply.
sorry, my lord.
Mm.
Yes.
So no, I'll come back to him, you can start.
Yes, my lord.
You are appearing for the informant.
Yes, my lord.
Oh.
Now, my lord, very limited scope before this, expect before this honorable court is, my lord, regarding the quashing of the FIR, my lord. So now, the quashing under 528 at the stage of investigation, my lord. The matter is under investigation. And my lord, no doubt during the pendency of this matter, my lord, the direction has been given by this honorable court, protecting the accused that no coercive action shall be taken
Problem also
against.
sometimes. In this.
Yes, my
Anyway,
lord. So now, my lord, because of that order, my lord, to some extent, my lord, the investigation is not progressing because he is not cooperating, first of all. Now, my lord, the material, whichever the petitioner side is relying at this stage, my lord, this is not the stage for relying all this document, my lord. Yes, my lord is well aware that at this stage, it is not absolutely bar. However, my lord, the material should be unimpeachable of sterling quality. If considered, then absolve him from the commission of the offense, my lord. That is the settled law, my lord. But now, my lord, so far as the present petition is concerned, my lord, we are bothered about the, my lord, whether the FIR does disclose the commission of the cognizable offense or not. As my lord is very aware of the Niharika case, my lord. Here, my lord, although the one of the accused, both the accused have stated that they have done it in conspiracy with this accused person, the accused number 2, 1 and 3.
who has stated?
My lord, this
1 and 3.
yes, 1 and 3. And my lord, during even the course of investigation, my lord, they have clearly revealed in the document whichever has been given by this present accused person, my lord. This is also the part of the case diary, my lord. As in when, my lord, my lord, as my counsel for the petitioner has clearly himself has admitted that the transaction all are illegal. These are illegal transactions done in a legal way, my lord, to obtaining this work and all, my lord. Now, my lord, this cannot be ignored by this court also because he himself has admitted one thing, that all these are illegal things. Where, my lord, the petitioner, the informant, he is also involved, my lord, assuming, because we are just taking his submission also. He is saying, my lord, all these are transactions, illegal one. Now, now the matter is in session of this court, when the court is dealing with a matter for quashing of the FIR. Now, they are saying it's illegal, all transaction is illegal regarding for procurement of the government work. And now, my lord, apart from that, that is the additional thing they have admitted. Now, my second part is whether this FIR disclose the commissible of cognizable offense or not. Because it is again, my lord, well settled that the civil, my lord, civil remedy as well as the criminal remedy can coexist, my lord. It doesn't mean that for recovery of money, they can file a suit. It doesn't absolve them from the offense they have committed, my lord. Even if it is recovered, it doesn't absolve them from the offense they have committed at that particular point of time. Because, my lord, the crime never dies. My lord, will kindly come to page 80 of the FIR, my lord.
80.
Page 80, my lord. 80, my lord. Page number 80, my lord. This is the, my lord, second page of the FIR. My lord will find in the, not the last paragraph, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. On the 11th line, my lord, will find after payment of aforesaid amount.
No, in the first paragraph or second
My
paragraph?
lord, first paragraph, there are 2 paragraphs, but first paragraph, my lord, after 11, my lord. Here, my lord, you will find, my lord, IFSC number is given there, and then Indian Overseas Bank branch Naharlagun. After, my lord, the line, I will read now. My lord, now we have to just find out whether it disclosed the cognizable offense or not, or it is absolutely of civil flavor, my lord. After payment of the aforesaid amount, the accused person came to my office on so and so with a letter bearing number so and so. Now this letter is important, my lord.
But he does not describe which accused person.
Yes, my lord.
Which one came?
Yes, my lord. The accused person, so and so, allocation of fund under so and so, rural so and so, against my firm, Messer so and so, purportedly shown sanction so and so. After going through the letter, I got doubt about the authenticity of the letter mentioned above. They told me that it's sent through WhatsApp from Delhi. I need to pay them again rupees so and so.
crore, so and so, so and so. Now, this part will be clear now in the second paragraph, my lord. The accused number 1 himself is a registered contractor and accused number 3 is a local lady. Now, my lord, the accused number 1 is the Tolum Lombu and 3 is the Dubu Ata, my lord. On good faith, I paid the aforesaid amount to them on dated so and so, and they assured that government release the amount very soon. I went to the office of chief engineer to inquiry about the allocation of fund and also the authenticity of the letter mentioned above. The chief engineer RWD informed that no such letter received and it was a fake. Now, so far as the fake is, my lord, forgery is concerned, the prima facie, this part is here. Manufacture and fabricated document. It is design, criminal conspiracy and impersonation act of the accused person. I called the accused number 1, now my lord, clear, to return my money which was fraudulently taken by them. Then the accused number 1 told me that the accused number 2 has done 2 now. Accused number 2, my lord, here, his role has been, my lord, disclosed. Rakesh Kumar Singh, the accused number 2. Money. The accused told that the accused number 2 has done all this conspiracy against me, who is a habitual offender, and all the accused person has shared the aforesaid amount. All means 3 of them has shared the amount. I therefore request you to kindly register a case and appropriate section of the law against the accused person and recover my money. I further looking forward for your consideration. So and so. Now, my lord, so far as the 180 statement of both the other accused is concerned, my lord. And also, my lord, not only their statement, my lord. For this is now we are dealing with the, my lord, quashing of the FIR. So if it is bail, then, my lord, it would be considered as 210 years, my lord. However, my lord, there are other material, the transaction between the other co-accused and the accused person, present accused person, are also the part of the record. And unfortunately, my lord, because he is not cooperating with the investigation, he is not progressing, my lord. My lord, so far as the statement of the other co-accused is concerned, they have clearly, my lord, stated his role. The document was, in fact, my lord, manufactured by the present accused person. And it was transferred to the, it was later on given to them. By taking that letter, they came to the present accused informant person, and he just took, to get the confirmation from his genuineness, he went to the chief engineer, their confirmation was given. Then, my lord, he said, no, you all have to give my money back because it is you have done forgery against me. So, in that context, my lord, they have disclosed the thing that it was all indeed did by the respondent accused number 2 in connivance with them. They all together have done it, my lord. So now, my lord, whether it disclosed the commission of cognizable offense or not, my lord, it says forged document which has never been, my lord, issued by the concerned authority, my lord. The forgery is there, my lord. And, my lord, if he has not any dishonest intention, then why, my lord, he will issue that document, my lord? He may have, my lord, earlier occasion, they may have done work together also, my lord. That is not an issue. That will not at all absolve the, my lord, the offense which he has committed in the present situation, my lord. It doesn't mean if a person has worked together with another person, later on if he committed anything, that will be seen in the different picture, my lord. That will get a different flavor or different cover cloak, my lord. So here, my lord, the FIR clearly disclosed indeed the commission of the cognizable offense. Now, my lord, so far as the material is concerned, my lord, the FIR, the case diary, my lord, clearly reveal the transactions, my lord. My lord will find this is the, my lord, the status report, annexed with the, forwarded with the, my lord, case diary, my lord.
Status report.
Yes, my status report, all, as on that, my lord, what has been received, what has been collected, what has done so far, has been part of the record. My lord will find in the second page, investigation so far, my lord. Investigation so far. Yes. During the course of it, my lord, may I read, my lord?
You want to read?
Yes, my lord. Won't be any.
But I'll go through. I'll go through it. I can go through it also.
Yes, my lord. My lord may go through it. My lord will find in the second page, after payment of aforesaid amount, my lord, in the last line, my lord, after payment of the aforesaid amount.
Wait.
From there, my lord, everything is there in implementing.
Let me read it from
Yes, ma'am.
investigation so far.
Yes, yes.
Okay,
Yes.
gone through it.
Yes, my lord. Here, my lord, after seeing the record, my lord, we cannot say that it's a purely of civil nature, my lord. No doubt, my lord, most, my lord, it is again well settled that in the most of the, this offense and most of the time, offense of cheating are committed during commercial transaction only, my lord. In most of the time, my lord. And, my lord, FIR does disclose the commission of the cognizable offense. Even it has been substantiated and supported by the material so, my lord, collected during the course of investigation, despite the fact that the present petitioner is not cooperating with the investigation, my lord. He is not cooperating with the investigation. And, my lord, so far as, my lord, regarding the quashing of the matter is concerned in this kind of case, my lord, I would like to rely some judgment of the effects court, my lord. Wherein, my lord, if there is a dishonest conduct, my lord, so far as, my lord, for 420, my lord, from the inception, there must be a dishonest intention, my lord, and fraudulent intention. However, my lord, for quashing of the FIR, if during the time, if court find that there is a dishonest conduct also, my lord, the court should not, my lord, stall or, my lord, the quash the, thwarted the investigation by way of quashing, my lord. My lord, this is 2024 SCC online, SC 2820, page number, my lord, paragraph, I will rely 16, 18, 19, and 20, on dishonest conduct, my lord. Para 16, may I read, my. Before we proceed to test the correctness of the impugn order, we
Which
must,
para, which para?
my lord, 16, 16,
16. Oh,
16.
yes.
Yes. Before we proceed to test the correctness of the impugn order, we must bear in mind that at the stage of deciding whether a criminal proceeding or FIR, as case may be, is to be quashed at the threshold or not, the allegation in the FIR or the police report or the complaint, including material corrected during the investigation or inquiry, as the case may be, are to be taken at their face value so as to determine whether a prima facie case for investigation or proceeding against the accused, as case may be, is made out. The correctness of the allegation is not to be tested at this stage. And para 18, my lord. It is straight law that FIR is not an encyclopedia of all imputations. Therefore, to test whether an FIR disclosed commission of a cognizable offense, what is to be looked at is not any omission in the acquisition, but the gravamen of the acquisitions contained therein to find out whether prima facie some cognizable offense has been committed or not. At this stage, the court is not required to ascertain as to whether a specific offense has been committed. It is only after investigation at the time of framing of charge when material collected during the investigation are before the court. The court has to draw an opinion as to for commission of which offense the accused should be tried. Prior to that, if satisfied, the court may even discharge the accused. Thus, when the FIR is alleges a dishonest conduct, my lord, dishonest conduct on the part of the accused, which, if supported by material, would disclose commission of a cognizable offense, investigation should not be thwarted by quashing the FIR. Here, my lord, this I would try to highlight, my here. No doubt, a petition of quashing the FIR does not become infructuous or submission of a police report under so and so of the CRPC. But when a police report has been submitted, particularly when there is no stay on the investigation, the court must apply its mind to the material submitted in the support of the police report before taking a call whether the FIR and the constitutional proceedings should be quashed or no. More so, when the FIR alleges an act which is reflective of an dishonest conduct of the accused. In the instant case, the FIR alleged that the accused took a original complaint track on a hire. But here in the present, the Supreme Court, which was Supreme Court dealing, the track was on hire for a period of starting from so and so at the monthly rent of so and so. But after payment of first month rent, the rent was not paid despite false assurance. The allegation that the rent was not paid by itself in ordinary course would presuppose retention of possession of the vehicle by accused. In such circumstances, as to what happened to that truck become a matter of investigation. If it had been dishonestly disposed by the accused, it may make out a case of criminal breach of trust. Therefore, there was no justification to the quash of FIR at the threshold without looking into the material collected during the course of investigation. Here now, my lord, here in this case, there is an allegation that they all have, my lord, has shared the money. Now, whether the money has been recovered, that is one of the questions. The money was used for what purpose, which has been taken. My lord, this can relate with this present case can be related with this case also. Although, my lord, here in the case of the Supreme Court, which Supreme Court dealt, there was in fact an agreement for hire, but the court has found that there was a dishonest conduct, my lord. So it will be revealed only after the investigation, my lord, what the actual offense he has committed. But now, in the present case also, my lord, this is under investigation and it's not progressing because, my lord, there is a protection from this honorable court. And moreover, my lord, he has not even taken trouble to, my lord, cooperate with the investigation, because definitely the police will not investigation authority will not arrest him, my lord. That he has not cooperated as on that, my lord. And secondly, my lord, my lord, time is, let it be continued after break, my lord.
You'll make your submissions for the
Yes, ma'am.
informant?
Yes.
Mm.
My lord, can I make one submission, my lord?
Yeah, just a minute.
My submission is very short, my lord. Now, it's now initial stage of investigation. Let him appear before the.
Some agreement has been made also by you?
That agreement, power of attorney has cancelled long before, my lord.
No, any agreement to settle the case? No.
No,
You want the investigation to
Let
be
the
continued?
precise.
let the investigation may be completed. If there is no evidence against him, the police will give a final order.
Okay.
Now, whether your lordship can work at this stage, whether your lordship can exercise inherent power, Honorable Supreme Court has stated, my lord, the judgment.
We'll take up
Yes,
after,
after break, ma'am.
at 2 o'clock.
Yes, yes.
My lord, can I make one prayer, my lord?
Yeah, sure.
My lord, I have a matter at 2, or can it be taken at
Okay.
2:30, my lord? My lord,
Yeah, why not?
just
No
a little
problem. You finish
accommodation
your
for half
matter.
an hour. My lord,
No problem. Absolutely no problem.
I'm deeply obliged.
Till that lodging of the FIR, the petitioner was pursuing to get married, Lordship. So there is no question of that section 69 probably at this stage. And already, Lordship, 52 days in custody, and on other day also I have submitted before your Lordship that the bank statement, that is from page 18 to page 32, where Lordship, both parties were in both parties were in financial transaction, Lordship. There were a number of transactions between both the parties. Page 18 onwards, and that is also reflected in your Lordship's last order.
The only concern was the threat from his side to make certain things viral, and due to which she had severe trauma and started remaining only in the house.
Lordship.
Right. That is the area of concern actually.
Only on that point, it was Lordship was pleased to reject their petition initially, my lord.
That was the area of concern. Today we have, it is still at the stage of investigation, right?
No, my lord, here charge sheet submitted, my lord. I have received the report, my lord,
charge-
from my lord.
Charge sheet has already been submitted.
My lord.
In that case, Lordship may consider my detention period and the fact that he was ready and willing to marry, Lordship. In that view, Lordship, probably 69 will not come. If other sections are there, he will face the trial, Lordship.
Lordship may also call for the scanned copy of the record, my lord. Please hear, my lord.
Already 52, and I am not relying on any disputed facts, which is apparent from the FIR itself, Lordship.
I would have liked to have a look at the charge sheet. You know,
My lord.
about the findings of the investigation.
My lord.
The
That is-
findings of the investigation.
Lordship may
But
call for
anyway,
transition.
Lordship may consider the detail. That is my humble servant, because at this stage, Lordship, already from the bank statement, I have already placed before Lordship that both parties were Lordship in the financial transaction. If there were any dispute between them, she would not have been she would not have deposited money in my account, or I
No,
would
that
not.
is not that is
Lordship.
not incompatible with the threat, subsequent threat.
No, that
You know, you have
transaction,
to-
Lordship may kindly see just before lodging of the Azahar, page 31, Lordship may kindly see. Second
Yes,
transaction,
31.
Lordship,
Yes,
13/4/2026.
Before after lodging of the FIR.
No, just before lodging of the FIR, Lordship.
36. What is the date?
Yes.
13?
13/4/2026.
13 for April.
Yes.
April. This is my only concern, otherwise it's okay.
My lord.
Lordship can put any condition, he will abide by that condition, Lordship, regarding that. And already her statement recorded, his mobile phone says everything has been seized, Lordship. On other day also, Lordship has seen that those were sent for FSL while rejecting my earlier bail application, Lordship. And it was awaited service report. So already all those electronic devices has been seized. If anything is found, he will face the trial. That is my case. Already 52 days, otherwise that is a case of
No,
60
that
days
is,
offense.
you will face the trial, that's okay, but the court's main concern is the, safety and, well-being of the girl. Because
Lordship
of
may
the
put
threat.
any condition that he will not, Lordship, he will not contact
those
the victim
conditions
girl
are
in
what
any
are-
manner. In that case, he may file for cancellation also for violation in the before the trial court also. Instead of going coming to this court, that liberty may be granted to the victim, Lordship. If he violates any time, a victim can file application before the trial court for cancellation. That liberty may be granted, Lordship.
Lordship, my submission is that, my lord, Lordship rejection order is, my lord, 2/7/2026, my lord.
I've seen this.
My lord, in the last
I've
para,
seen.
my lord, 34, my lord, it was
I've
observed that, my
I've
lord,
seen.
my lord. And in the
I've seen.
subsequently, my lord, charge sheet of submitted, my lord. At this stage, Lordship may call for scan copy of the PCR, my lord, for finally dispose of the matter.
Mr. A. Ahmed and learned additional PP for the state. Full stop. You from the page 33, no, earlier order, para 1, 2, para 1 and 2. 1, 2 and 3 you take. Full stop. This is a subsequent bail application, as an earlier bail petition was rejected on 2/7/2026, passed by this court in BA 1745 of 2026. Full stop. Next paragraph, Mr. Ahmed, the learned counsel for the petitioner submits that the court may consider his length of detention till date, which is about 52 days, and also the aspect of completion of investigation. Full stop. It is submitted by the learned counsel to address the aspect of safety of the girl. Any strict conditions may be imposed, and the petitioner shall have to abide by the same. Full stop. On the other hand, the learned additional PP submits that submits that in the meantime, investigation is completed. Have I said that earlier? No.
No.
Submit that in the meantime, investigation stands completed and has resulted in a charge sheet. Do you have the number?
My
Right,
lord, my
CS number.
I charge sheet number 53 of 2026, dated 28/7/26.
28/7.
My lord.
Full stop. The learned additional PP praise for calling the scan report at this stage. Full stop. I have given my consideration to the matter. Full stop. The call for the scan TCR comprising pertaining to so and so case number. Do you have the GR number? We'll see. We'll check it. Pertaining to so and so from the learned code below. Next. Full stop. In the next paragraph. In view of the length of detention and completion of investigation, it is directed that in the interim, the accused petitioner is hereby allowed to go on bail of ₹50,000 with one surety of the like amount to the satisfaction of the concerned learned court, and subject to the following conditions. Number 1, he shall be available for trial if on commences. Number 2, he shall not hamper or tamper with evidence. Number 3, he shall not in any manner contact the informant/victim girl, or shall not in any manner harm or harass or intimidate her. Next paragraph. He shall not commit any illegal activities. Next paragraph. Violation of the bail conditions would entail cancellation of the bail. List. You can list it in the succeeding week or
Lord.
a little thereafter, after I come back. Let him go out in the meantime, but I just have a look at the charge sheet.
My lord, 20, my lord, 20 August. 20 August.
20. Mr. Ahmed, you also convey to him,
Lordship.
that Mr. Ahmed, you also convey to the petitioner.
Lordship,
that he
I
should
will
just,
inform him the condition.
inform him, and he should not disturb her.
Lordship.
Other things will proceed according to law.
Lordship.
Okay, list on 20th August.
I'm obliged.
Obliged.
Yes. That matter is 2:30. The ongoing matter is at 2:30.
Item number 10. Somebody want to mention?
Yes, 9 will resume at 2:30. So, Learned Counsel sought some accommodation. He has some matter. Unlisted matters. I see list. Money.
May I beg your lordship?
Hmm.
Your lordship, I would beg to mention item number 29, my lord. Speaks for hearing. My lord, I have some domestic urgency, my lord.
All of them will not reach in any case.
Yes, ma'am.
So 29 might reach also. You want an adjournment?
For day after tomorrow, my lord.
Learned Counsel for the appellant submits that he has some domestic urgency, due to which the matter may be adjourned today and taken up on another day.
On 5th, my lord.
He prays for listing the matter on 5th August. Prayer is allowed, list on 5/8/2020 for hearing.
Majab.
Item number 34, unlisted bail motion.
If counsels are there, we can take up. Excellent. You. If you are ready, we can take it up.
Let the council, let it be passed over for the timing. Item number 34.
Item number 35,
Yeah, please, my lord. My lord, by way of this application, I'm praying for some protection from this honorable court. My lord, my lord has dealt with similar kind of nature of offense, my lord, in the FIR. My lord will find the FIR at page number 22. It was in respect of the premature closure of the fixed deposit by the then branch manager of the UCO Bank. And
The same matter, same
same
FIR.
matter, my lord.
Same
And
FIR.
the principal accused and one of the employee
Pranab
been
Das.
protected by this honorable court. My lord, may kindly have page number 22, that is the FIR. And 26, my lord, is the order passed by this honorable court. Twenty-two is the FIR, 26 the order. Now, I'm not named in the FIR, in fact, my lord.
You're
And
not.
during the course of the investigation, my lord, the husband of the petitioner has been arrested, who was the cashier of the UCO Bank.
Right.
My lord will find at page number 24.
Morik Pakam. No, she's Morik Pongkon. I think
Bharti Ingo 24, my
if
lord.
this is the name, then she's named. They might have given the name wrongly, is it?
Morik Pakam is the one of the applicant here, my lord. Is the
Morik
petitioner.
Pongkong, he's a different person.
That's a different, she's a different person.
And similar name.
Sim.
She's Morik
Just a second.
Pakam. She's a different person. No?
She's a different person, my lord.
Pranab Das is named
Pranab Das is
and
named
Morik Pongkong.
Morik Pongpong.
They are different persons.
She's totally different person, my lord.
Okay.
They are in fact not named in the FIR. I was in fact going through, I was making a submission in item number 36. In 35, my lord, the present accused who was arrested, who was the cashier of the UCO Bank, is my brother-in-law, my lord.
And she's also working in
No, I'm
UCO
not
Bank.
working. I'm not working. My
Okay, no. How is she related to?
well, he's my brother-in-law and he was arrested.
I see.
And there was some transaction, in fact, between brother-in-law and the sister-in-law. So that is the reason.
Brother-in-law's name is?
Name is my lord will find.
Okay, no problem.
At page number
No,
24, my lord.
no problem. Yes,
24.
got it.
Renya Ingo. Renya Ingo.
Miss Hage? No,
No.
I also thought it's a different person. It's similar.
So, my lord, on the similar
Okay.
ground, respect of order passed by this honorable.
Jumbi, you can go to page 26 and you can take para 2 and 3 regarding the allegations. Next paragraph. The Learned Counsel submits that the present petitioner is not named in the present petitioner, namely so and so, is not named in the FIR, and that the person named Srimati Morik Pongkong mentioned in the FIR is a different person. Full stop. It is submitted that one of her brother-in-law, who is a cashier, who was in the said bank, this is also order of mine.
24.
This is my order is also in the same
Yes,
case.
my lord. In page number 26.
Same case. You can take from here. Take from here. Rest will be same. Stop. One of our brother-in-law was arrested. Was working as a cashier in the said bank. Was arrested, and that as there were some transaction. There were some legitimate transactions between the petitioner and her brother-in-law. She is apprehending that she may also be called and perhaps arrested in the case. The Learned Counsel has also submitted that in order that in AB 83 of 2026 and AB 91 of 2026, this court wide orders dated 22/7/26 and 29/7/2026 was pleased to grant interim bail to two other persons, including named accused.
Named accused.
Named accused. The petitioner seeks a similar interim protection as well. Ms. Hage, Learned additional PP submits that case diary may be called for at this stage. Next paragraph. The same, like the earlier order, will be same. You can give it. Call for the case diary and upon giving my consideration to the prayer for interim production, including the aspect of interim bail granted to other persons, two persons connected with the case, it is directed that rest is same. You can fix it together with the other matters. List on 10/8.
10/8, my lord, I'll be going out of station, my lord.
Okay.
So
Because these two matters will come up in any case,
Yes,
because we have fixed it.
in AB number 83, 2026, my lord, this matter has been fixed after 2 weeks on a date to be fixed by
2
the
weeks,
registry.
But in the order that I passed the other day,
The earlier order.
yeah, I said 10/8 along with AB 83. So it will
Okay.
come, but someone has to seek an adjournment on your behalf, right? So when will be convenient for you?
My lord,
Because the diary will not,
17th August, my lord.
okay, 7th. Yeah, that's true. That's true. But someone he has to take adjournment. 10/8, 10/8, then take adjournment. That will be more systematic. 10/8.
My lord, item number 36, I'm the wife of the person who was arrested, my lord.
Wife of the person.
Person who was arrested recently, my lord. Other one was sister-in-law.
Okay. Wife and sister-in-law.
My,
Wife is also apprehending.
yes, my lord. In fact,
Then only thing that will be different is that that line. The present petitioner, it is submitted on behalf of the petitioner that her who is she? What is her name?
Bharti Ingo, my lord. Bharti Ingo.
Morik Pakam,
That was item number 35, my lord.
Bharti Ingo, yes.
Bharti Ingo, item number. She's also not named in the FIR, my lord.
So that will be same, not named in a FIR, and it is submitted that the petitioner's husband, who was working in the concerned UCO bank, was arrested during investigation of the case, and therefore she also has some apprehension about being arrested. So, and hence seeking anticipatory bail from this court. Rest will be same. Date will also be same, 10/8, and you get it fixed on something or something
Grateful.
together. You're getting the scan copy, right? Scan.
Item number 34, unlisted motion matter.
Are you ready? So, no, BA 72. No? 72. No.
My lord, I would like to withdraw this bail application.
Withdraw.
Yeah, there is some required some amendment.
Okay, as you wish, no problem. Good name, please.
Tidukom.
Learned counsel for the petitioner submits that he has instructions to seek withdrawal of the bail petition. The prayer is allowed. You will file a fresh
Yes.
withdraw
to
this
file.
bail application, comma, however, with a liberty to file afresh, as some errors have crept into the present bail application. The prayer is allowed. The instant bail application stands disposed of upon withdrawal with a aforesaid liberty to file afresh.
Item number 10,
Bad peace, lords.
Criminal appeal has come or the IA has come?
Yes, lords.
The first time?
Yes, lords.
Oh. Appeal will admit, right? What is the sentence? Full years? How many years?
3 years for under section 307 IPC and 2 years, 6 months for the under section 326. Lords.
Heard Mr. Learned counsel for the appellant and Mr. Ate learned additional people for the state. The appellant respond number 2 notice is not essential in this kind of cases. You want to notice? You can send a notice. So since you have implemented, always a good idea. The appellant has invoked section 415 within bracket 2 of the BNSS in filing this appeal against the judgment and order. The judgment dated 26/6/2026 and sentence order dated 30/6/2026 passed by the learned session judge, SEPA Division, East Kameng District. In, what is the case number? In sessions case number 6 of 2024, within bracket arising out of SEPA PS case number 8 of 2023. Full stop. By the impugn orders, the petitioner, the appellant was convicted under section 307/326 IPC. Full stop. For conviction under 307 IPC, he was sentenced to undergo SI or RI?
There is a
There is a provision in General Clauses Act that if you not mention. Some sections of POCSO you find, they don't specify the imprisonment, only imprisonment. Ideally, it should be. That is very good. That's settled. Yes. Yes, life imprisonment, don't have to say that. It is rigorous only. Okay. 3 years imprisonment and fine of 1,000, in default 3 months imprisonment. For 326, conviction under 2 years, 6 months imprisonment, fine of 1,000, in default 3 months imprisonment. Next paragraph. However, the sentences were directed to run concurrently, and the appellant was also given the benefit of set-off. Next paragraph. The appeal being a statutory first appeal in criminal law against conviction and sentence of imprisonment is admitted for hearing. Call for the original TCR of session 6 of 2024 from the Court of the Learned Session Judge Sepa Division, East Kameng District. Full stop. The notice extra copies may be furnished to the prosecution if necessary. The petitioner is impleaded the informant as respond number 2, right?
Yes.
Informant, victim or
Victim,
victim.
victim,
He is also the informant. Informant come victim.
no loss.
The victim as respond number 2. Steps of notice may also be taken upon say respondent. First.
Lordship, there is an IA
I
for,
will come to an I know. So we'll fix this after receipt of TCR.
My lord.
Sometimes it gets
After receipt of the TCR, my lord.
list the matter in the orders column after receipt of the TCR by the registry.
yes, ma'am.
It will be in the orders column. He is presently on bail or custody.
Yes, President Bell.
He's on bail.
Yes, Lordship. This IA is for continuation of Bell, Lordship.
That's okay then. But you can submit fresh bail bonds.
Press bail on will be required, my lord. Would be that will be more
Better.
appropriate. Yes.
But previous bail can continue.
Yes, ma'am.
By judgment dated so and so, order of sentence dated so and so, the petitioner was convicted under section 307, 326 IPC and sentenced as follows. You write that from there. The applicant has preferred a statutory criminal appeal, which has been admitted today, and records call. Full stop. This IA is for suspension of sentence and bail in exercise of powers under section 430. 389 is 430 now.
Yes,
Yes, ma'am.
430 of BNSS. Full stop. It is submitted that we'll dispose it often.
Yes, my lord.
Yes,
Yes.
No notice is necessary. The instant interlocutory application has been filed for. So it is submitted that the petitioner is on, the appellant is on bail at present. And the learned counsel submits that he may be allowed to remain on bail by suspending the sentence. The learned additional PP submits that perhaps the applicant may be directed to furnish fresh bail bonds before the learned trial court. Next paragraph. Considering the nature of the sentence and the fact that the petitioner, the applicant is on bail, and there might not be immediate prospect of disposal of this criminal appeal, of the connected criminal appeal, it is directed that till the disposal of the criminal appeal, the execution of the order of sentence dated 36/2026 passed by session judge so and so in sessions case so and so shall remain suspended, and the appellant is allowed to remain on his previous bail. However, the appellant may shall submit fresh bail bonds before the learned trial court, in which case appropriate orders may be passed. That's all.
Yes.
The following conditions are also imposed. Now, he shall be available to receive the appellate judgment. Number 2, he shall not commit any harm, harassment, or intimidation to the informant / victim side or and oblique or any witnesses who had deposed during the trial. The IA stands allowed and disposed of on the aforesaid.
Obliged.
Item number 9,
Yes. You completed your submissions?
Yes, my lord. I'm just relying, my lord. I've relied judgment, my lord. Now I will relate one or two more judgment. Then I will conclude my argument.
Oh, yeah. You are planning to submit a judgment. Move the roll. Yes. Yes, please.
I've already relied the judgment, my lord, earlier.
Yes. I have.
That was pertaining to, my lord, dishonest conduct, my lord, at the stage of investigation, my lord. So now the matter is also under investigation. My lord, then two more judgment. One is on, my lord, at the nascent instance, my lord, the court basically court may not staple with the investigation by quashing the same, my lord. That has been reiterated by the Supreme Court in my lord, Puspendra, my lord. This is still not yet reported, my lord, but this is the copy of the Supreme Court judgment itself. My lord, you'll find a Puspendra.
Yes, para.
Para, my lord, 11, 12, and 13, my lord. This is a case of May, my lord, 29 May 2016. My lord, I will rely para 11, 12, and 13, my lord. Allow me to read, my lord, para 11 onward, my lord. Para 11, my lord. Delay is one of the factors which the trial court may take into consideration while appreciating the overall evidence that may come on the record in the course of trial. Delay by itself without anything more cannot be ground for casting. This is not the case here. Now, 12, my lord. The learned counsel appearing for the respondent number 3 and 4 respectively vehemently submitted that the FIR is politically motivated. This contention also cannot be a ground to quash the FIR at the nation stage. Now, I'm just emphasizing.
If there are materials to indicate
Yes, my lord,
that
absolutely.
it is politically motivated, that means malified.
Yes, my
Which
lord.
is one of the grounds in Bhajan Lal.
Yes, my
So
lord.
then it can be.
Yes, my
Then
lord.
it can
Yes, my lord. But here also, my lord, it says, my lord will find, my lord, what is the Supreme Court, my lord, saying? This contention also cannot be a ground to quash the FIR at nation stage. At nation stage, my lord, it should not be taken into consideration.
Unless you have you are convinced
Yes.
at the nascent stage itself,
Yes, my lord.
on the basis of materials, that it is a malified.
Yes, yes. Then, my lord, that can be done. But, my lord, what if we, my lord, consider this Narika case also, my lord? What difficulty basically face at this stage is, my lord? The all facts are hazy, actually. Once charge sheet is filed, my lord, then the court is in the better position to, my lord, go into all this aspect, my lord.
Investigation is a emerging situation.
Yes, my lord, absolutely, my lord. Now, here it says, at the time of considering the case for quashing of the FIR, the High Court is expected to look into the nature of the crime, the nature of the allegation level, etc. In other words, what is important for the High Court is to see whether the FIR disclosed commission of any cognizable offense or not. That much, my lord, very limited scope is there. So far as, my lord, the quashing of FIR is concerned. Now, 13 is, my lord. But basically, if we see, my lord, the 12 is nothing but the reiteration of, my lord, Bhajan Lal, my lord, one of the my lord, parameter. But it also says, my lord, if it nation stage, that may not be taken into consideration if it disclosed the commission of cognizable offense. Now, 13 says, we take note of the fact that the High Court has not said a word or discussed anything insofar as the nature of the allegations level in the FIR is concerned. It is expected of the High Court to give a fair idea in its order as regard the content of the FIR, what type of allegations have been leveled in the FIR. The entire FIR may not be reproduced, but at least when the matter travel up to the highest court, then if something is observed in its impugn order as regard the content of the FIR, nature of the allegation, that would be helpful to understand whether there has been proper application of mine at the end of the High Court. Now, my lord, this is just the guidelines to the High Court, my lord. Even if it is quashed, the reason must be recorded, my lord, on what reasons are there, what is there in the FIR. Now, my lord, the last, the judgment, this judgment is pertaining to, my lord,
criminal remedy as well as civil remedy can coexist, my lord. It doesn't mean that if civil remedy is there, that inference cannot be drawn that civil remedy is there, so you cannot invoke the criminal remedy. Both are operating in different sphere, my lord. Civil remedy is for damages, criminal remedy is for punishment for committing offense. Now, this is reported in 2025 SCC Online SC 2713, my lord. Rocky versus State of Telangana. My lord, para 24, I would refer 24, 27, 30 and 32, my lord.
Para 24,
24, 27, 30 and 30 to 32, my lord. My lord, para 24, my lord. May I read, my lord? Para 24. Yes, ma'am. The appellant's core contention that the dispute is purely civil in nature is untenable at this stage. Although court must guard against giving criminal color to civil dispute, it is equally well settled that existence of civil remedy does not preclude criminal prosecution where the allegation disclose essential ingredient of an offense. Now, my lord, may kindly directly come to para 27. In a case of Pradeep Kumar Kesarwani Supra, this court outlined the structure 4-step test to assess claim for quashing under section 482 of the CRPC. The material relied upon by the accused must be of, my lord, now it's talking about, my lord, I have submitted on what kind of material can be relied upon at the stage of quashing of the FIR. And it says, my lord, the accused must of sterling and impeccable quality, sufficient to completely negate the allegation, uncontested or incapable of legitimate contest by the prosecution, and such that continuing the trial would amounting to abuse of process. Unless all 4 tests are satisfied, madam, all tests has to be satisfied, madam. Quashing is unwarranted. The relevant paragraph of the said decision read as under. The following steps should ordinarily determine the veracity of a prayer for quashing raised by an accused by invoking power vested in the High Court under section 482 of CRPC. 1. Step 1. Whether the material relied upon by the accused is sound, reasonable, and indubitable, that is, the material is of sterling and impeccable quality. 2. Step 2. Whether the material relied upon by the accused would rule out the assertion containing in the charge level against the accused, that is, the material is sufficient to reject and overrule the factual assertion contained in the complaint, that is, the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of acquisition as false. 3. Step 3. Whether the material relied upon by the accused has not been reputed by the prosecution complaint and or the material is such that it cannot be justifiably reputed by the prosecution complaint. 4. Step 4. Whether prosecution with the trial would result in an abuse of process of the court and would not serve the ends of justice. If the answer to all the steps is affirmative, judicial conscience of the High Court should pursue it to quash such criminal proceeding in exercise of power vested in it under section 482 of the CRPC. Such exercise of power, besides doing justice to the accused, would save precious court time, which would otherwise be wasted in holding such a trial as well as the proceeding arising therefrom, especially when it is clear that the same would not conclude in conviction of the accused in so and so Rajiv Thapar and so and so. Now, my lord, we can come to para 30, my lord. On perusal of the above mentioned judgments, it is clear that the present case does not fall within any of the narrowly crafted circumstances in which quashing may be justified. As held in the Bhajanlal Supra, the allegations are neither absurd nor patently improbable, nor is there any express legal bar for prosecution. At this stage, the court cannot embark upon the evaluation of reliability or genuineness of the allegation or the defense document. It is pertinent to note that the High Court, after analyzing the record, correctly concluded that the ingredient of offense under section 406 of IPC were not made out and therefore quashed the cognizance under that provision. However, the High Court also found that the allegation prima facie disclosed the element of the offense under section 423, 44 and 506 of the IPC and thus rightly refrained from quashing the proceeding relating to those offenses. It is treated that the power under section 482 of the CRPC is to be exercised sparingly with circumspection and only in exceptional situation. Court must avoid delving into disputed fact at the pre-trial stage. Interference is warranted only where the case clearly falls within the recognized parameter for quashing. My lord. Now, my lord, prior to this judgment, my lord, which I have relied, my lord, there also, my lord, one of the parameter of the Bhajanlal has been, my lord, indeed, my lord, reiterated. But Supreme Court says, my lord, not at the very nascent stage, because the facts are hazy. And court has only confined to consider whether FIR does disclose commission of cognizable offense or not, my lord. And here, my lord, again, my lord, the Supreme Court says, my lord, the criminal remedy and civil remedy can coexist, my lord. It doesn't mean one civil remedy is there, then criminal remedy cannot be invoked, my lord. So now, my lord, so far as the present case is concerned, my lord, the FIR does disclose commission of, my lord, cognizable offense, my lord. And interestingly, my lord, recently, my lord, I have the judgment, but not before me. That, my lord, one of the cases, there are 4 or 5, my lord, accused were there in the FIR. The Supreme Court has quashed, my lord, 3, my lord, the accused, because they are not named in the FIR, and there was no any, my lord, any ingredient against them regarding 498A, my lord. Later on, my lord, charge sheet was filed, trial comments, my lord. Then, my lord, again, Supreme Court held that, my lord, the 319 can be exercised against them again. Although they were not in the FIR, it was quashed. But the quashing of the FIR under 482 doesn't mean the acquittal. So they can again be, my lord, aired as an accused in exercise of 319. Yes, my lord. Listen, this, my lord, I will furnish that judgment, my lord.
That's the 319 would be in a different domain.
Yes, my lord. So now, for this, my lord, this case, what
But
I'm
the caution was at the stage.
Yes, my lord. If FIRs, my lord, the present situation, even if suppose, assuming, my lord, there is material is there, but not that not against this accused person. If it is quashed, for example, my lord, illustration, my lord. If this goes and charge sheet is filed and trial commence, during the trial, if cogent evidence come, my lord, then, my lord, and it found to be credible one if unrefuted lead to conviction, then in such case also the accused which has been whose petition has been allowed and which has been quashed by the High Court, they can again be tried by invoking 319, my lord, because the quashing of the FIR, my lord, under 482 is not an acquittal, because it has not, my lord, gone through the rigor of, my lord, the trial, my lord. So, my lord, in the present case, so far as the allegation against the accused is concerned, my lord, it clearly, my lord, disclosed the commission of the cognizable offense, my lord. Now, my lord, even if they have settled in the police station whatsoever, my lord, the stand they have taken, my lord, that cannot be taken into consideration, because that is not coming from the prosecution side, my lord. And moreover, my lord, no doubt, it is well settled that the commercial transaction, this can be considered if they have settled the matter, but not when the matter is considered on merit, my lord. At this stage, the court has to consider the case on merit, and if FIR indeed, my lord, if does not disclose any cognizable offense, then it has to be quashed. But in the present case, my lord, the FIR does disclose cognizable offense, and the present accused is also, my lord, named in the FIR, and his role attributed by the accused has also been disclosed by the other co-accused, my lord, and which is substantiated by the other, my lord, the 180 statement of the other co-accused in the charge, my lord, this case diary also, and also the bank transaction, my lord, where this certain amount has been transferred to his account also, my lord. And, my lord, I will conclude my argument with the submission that, my lord, after direct interim protection to the accused by this honorable court, my lord, he is not cooperating with the investigation, my lord. Although, my lord, even if he cooperates, my lord, no coercive would have been taken, my lord. But, my lord, will find in the status report itself, in the last, my lord, part, my lord, it has clearly been reflected that he is not cooperating with the investigation, my lord.
Okay.
My lord, we find in the status report, my lord, column number, my lord, 6.
I got
Column number 6, my lord. There also, my lord, he is not cooperating, my lord. From this, my lord, his conduct itself, my lord, shows, my lord, because of the protection advanced by this court, my lord, he is not cooperating. And because of that only, in fact, my lord, investigation is not progressing, my lord. That much, my lord.
Mr. Derry.
I'm also, my lord, on the same thing, my lord. It is now in the initial stage of investigation. Now, whether your lordship can exercise power, inherent power, my lord, at this stage, my lord, in the initial stage, my lord. Honorable Supreme Court said, my lord, that there is reportable judgment, my lord. Recently, it was passed. Here, dispute
with regard to my lord sell deed, they came before this Honorable High Court for quashing because there is a civil dispute. But the Honorable Supreme Court said, my lord, is paragraph number only relevant paragraph, my lord. Paragraph 53, my lord. In such circumstances, while exercising inherent jurisdiction should not
Just a
prevail
minute,
beyond
page number.
Well, page number 29 is in the bottom. Para 53,
Let us be on the same page.
page 29.
Page 29, para 54.
Para 53, 54, and my lord, I realize 55 also.
Para 53. Let's start.
53, my lord. In such circumstances, while exercising its jurisdiction should not travel beyond the allegation contained in the complaint and material placed by the complainant in delivering with defense sought to be projected by the accused respondent. The fact in the present case in hand manifests that the High Court proceeded to examine the document relied by the accused respondent, that is regarding a sale deed, including a sale deed executed in their favor, treated the same and determinative of dispute and observed that the sale deed must be cancelled and delivered first before criminal law could be set into motion. Such exercise was clearly beyond the permissible and scrutiny in a petition for quashing under Section 482 CRPC. Considering the defense materials, including the sale deed and other documents, would necessarily involve adjudication on disputed question of fact, which falls squarely within the domain of investigation. If necessary, trial any such exercise at the stage of 156 CRPC would amount to conducting mini trial and would wholly impermissible, permitting such defense material to which at the threshold would frustrate it and defeat the very purpose of directing the investigation by police. A direction, one case FIR was lost, in another case, my lord, complaint was filed before the judicial magistrate. So direction was the given for investigation. Then they came before the High Court. So Honorable Supreme Court said, my lord, it cannot be passed at this stage. Let him appear, my lord, since there is an interim order, let him appear before the police, record his statement. If there is no case against him, my lord, police will file an FIR. Now, my friend has stated in paragraph number 4, I got a contract through him. This is not true, man.
Para number
Paragraph 4
of your
of the petition, man.
of the bail petition.
Yes, main petition.
Para 4.
Para 4. He stated that I have gotten contract work through him. That is from MKCL Infrastructure Limited based at Ahmedabad. That company, they did not know him, my lord. I personally went there. It is also a disputed fact whether he is allotted through him or not. But to my instruction, no such work was got for him. And kindly see, my lord, paragraph number 4, his profession. From his statement itself, is reflect his conduct. Paragraph 2.
Paragraph 2.
Yes. Petitioner is a businessman by profession having various business interests range from restaurant to selling iron and steel. Petitioner also actively involved in consulting to other business involving interceding and mediating between the contractors. This involved that he is also doing our act as a middleman by taking money from the innocent people. This is my humble submission. Other material is my planet PP has already. So, my lord, since there is an interim order, let him appear before the police. Investigation maybe go on. Yes, ma'am. At this stage, your lordship may not
Reply. Yes. Please
May it please your
give
lordship.
your reply.
Yes, yes. But I'll start where my learned friend has ended. Thus indicating para 2, my lord. My lord, I'm doing a legitimate business because of which he has worked with me. And my lord, I'm paying taxes. So that's not an illegal business. What I'm having, I'm disclosing, my lord. And my lord will kindly take note of, I'm not very sure which of the orders, in which opportunity was provided by this honorable court to the private respondent informant to file their objection. They have declined to file this objection. And without filing that objection, my lord, it doesn't lie in their mouth to contradict any of the statements, my lords.
Anyway.
That your lordship may record, my lord, because they have not filed any objection, they have declined, in fact. Now, verbally, they are trying to decline some of the statements, my lords. Now, your lordship would see the emphasis is more on that I appear before the police. That is the mala
That
fide
may be
intent.
their contention, but since he got an order of interim protection, then why he has not appeared? He should have appeared. Interim order has been extended also for a long time.
Circumstances is such, my lord. My lord, we have tried to make out a case for passing by before your lordship's notes. My friend has spoke about dishonesty. My lord, dishonesty doesn't come. If your lordships kindly have a look again, now your lordship is aware of the entire facts of the case. My lord
No,
will
he has
kindly
no
page
explanation
53.
why he has not cooperated with the investigation, despite being protected by an interim order. Right.
What he is apprehending is, my lord, he is still apprehending action from police because the manner in which these people had come. My lord, none of my
Has he filed any application for anticipatory bail?
No, that application has not been filed.
Then
That has not been filed, my lord. My lord, so far as my apprehensions, my lord, I have disclosed in my petition itself in what manner police has come. My lord, your lordship would see. For the timing, if your lordship would see, there are serious allegations against accused number 1 and 3. They have taken to police station. My lord, they have detained there. They have never been arrested, and both of them accompanied Naharlagun police and come to Guwahati, my lord. In these circumstances, I have to approach your lordships. And my lord, talking about my intent, my lord, I have clearly indicated that I have business relations with all three of them. And now your lordship would kindly see page 53. When bona fidely I have, my lord, before even lodging of that FIR, it is I who had acknowledged this.
53.
Yes, my lord. And my friend says that dishonesty should be at the initial stage. My lord, this is my honesty at the initial stage, even before lodging of the FIR.
Page 53.
Page 53, my lord. And this document is the only thing that they say that this implicate me because I have admitted. Lord, I have also given the circumstances and the bank accounts in which under which the transaction has taken place from accused number 3. My lord will see acknowledgement come declaration. We so and so. These are both of the acknowledge the receipt of amount of so and so from transfer from Tayo lower ending. So, my lord, the liability which has been taken by respondent number 3 on whose account, sorry, my lord, the accused number 3 in whose account this money has been transferred. And we have also given a Lord, indication that Mr. Lord, the other gentleman, Mr. Talum, has nothing to do. He has transferred the amount. These are in respect of the transfer of money. Lord, I was not aware what has happened totally in that case. Only because I had business dealings and there, my lord will also see the informant has a prior business dealings with me. Even his vehicle as on today is with me, my lord. I am paying the installments. My lord, he has not implicated me directly, my lord. It is only through that the statement is made. Now, my lord will see the date. It is 10th of July 2025. FIR is lodged on 5th of September 2025. My lord, if at all I had dishonest intent, my lord, it could not have been that I have issued this acknowledgement, my lord. What this gentleman was needing was the money, my lord. And that's why your lordship would also take note of the agreement dated 49. But they have not disputed this agreement.
This acknowledgement has an interesting statement.
Yes.
May I read it out? The amount was transferred by Mr. Tayo through Taluk Lombi for pursuing his contractual matter by deploying our source.
Yes.
But
Look,
the same could not be materialized.
Yes, my lord, that is what I have to make, I have been
Pursuing
made to
his contractual
understand.
matter by deploying your source. It raises all kinds of questions
It,
about
it
the
does
allegations.
raise, it does raise, my lord, but your lordship would see this is a statement
Because
prior to the,
this sentence, what I'm trying to point out is that this
my
sentence
lord.
in your acknowledgement is your own voluntary act. No
Yes,
issues.
yes,
That's
no
good.
dispute
That is
regarding that.
appreciable. But this sentence, I mean, maybe he has truthfully said it, but this sentence can be, it can be negative also. It can be positive
Yes,
also, but it can be
yes, yes,
negative also.
Lord,
Anyway,
I
we
am
can also
obliged to
see
your
it like
lordship
that.
for that. Lord, at least,
We can also see it like that he has frankly admitted it. That also we can see it like that.
yes, yes,
Or we can see it negatively also. But anyway,
yes, my lord, but at least
it
I am
discloses
honest.
some frankness, no doubt.
Yes, now your lordship would see that agreement dated 14/9. But this is
Okay,
a
at
document
page, I will see, I'll go through all this.
here. Just I indicate what is the, my lord, my lord. I have already read page 56.
56.
My lord will
Yes,
see
agreement, yeah.
This is an
Agreement
agreement.
between A1 and the informant's enterprise, right?
Yes. What this sums up, my lord, this is not a manufactured document. This has never been
Tayo
disputed.
enterprise.
This is an impeccable document, as my learned friend says, my lord. I am obliged to him that this is a contemporary document on 49, my lord, on the date of lodging of that FIR. This suggests, my lord, that entire thing is taken by Mr. Lombi and he will settle that amount, my lord, the case is over. Not a whisper. Now, my lord, that's what I say, my lord, that how I have been framed into it because of the acknowledgement. My lord, that does not correlate to it. And he's satisfied himself, my lord, if he is paid by Mr. Lombi. My lord, so far as civil case is concerned, I am not projecting it as a case, it's a civil dispute as such. Why I am pointing out that civil case was because when I was forced, my lord, to issue checks and my friend as guarantor, it was a NI Act liabilities would come into play. That's why we sought a declaration from the civil court that that agreement was executed under force and coercion. So that check should not be encashable, my lord, no liability I have. That's what. I'm not saying that this has directly has a link with it. I say that consequences of event that has taken place. In what manner, my lord, they have come to Gauhati, my lord. My lord, both my learned friend are silent on this aspect of the matter. Perhaps the call record or CD will reveal, my lord, how they have been treated, my lord, in police station on 14/9. How they have come to Gauhati along with whom. My lord, I have been issued notice which has returned back to them. I am not even aware that notice have been issued, my lord. So the circumstances clearly makes out a case of mala fide intent on the part of the informant, my lord. And now they have tied up with this gentleman, my lord, the other informant. But there is not a statement to the effect that the informant being in a relationship, if he doesn't know me, that's a different thing. But he has been doing business with me, my lord. He had not directly alleged me. He only says that accused number 1 has made statement against me. And lordship has seen, because of the settlement, he himself has arrived, my lord. And nothing is there against me in that settlement.
Okay.
I'm deeply obliged, your lordship. And lord, my friend has relied upon those judgments. So far as proposition is concerned, there is no dispute at all. Bhajan Lal is the classic case, my lord.
Okay, no problem. I'll go through at those.
I'm so deeply obliged, lord.
No problem. You can leave your, I'll dictate a part of the order. Leave the rest in the chamber. But if you have another court, you can proceed. Some leaving your junior or someone.
No, Lord, I am here, Lord. I have done
Third,
my piece at 2 o'clock.
Rakesh Dubey, learned counsel for the petitioner. Mr. Ate, learned additional PP for respond number 1. Is the respond number 1, the state, and Mr. Deori, learned counsel for respond number 2. Invoking the jurisdiction under 528 BNSS, the petitioner, Sri Rakesh Kumar Singh, is seeking quashing of Naharlagun PS case number 123 of 25 under so-and-so section, which was registered, which was registered based on an FIR dated 5/9/2025, lodged by the respondent number 2, Tayo Talem Reding. Full stop. In the FIR dated 5/9/2025, the informant named three accused persons, apart from three accused persons, including the present petitioner, being Taluk Lambi within bracket A1, comma, Rakesh Kumar Singh A2, and Dubi Ete A3. Full stop. The gist of the allegations was that the petitioner, as a class 1 contractor, had secured some contracts and some bills pertaining to, in the rural works department, and some bills amounting to rupees 17 crore 90 lakhs 37,000 were pending. It is alleged that in the backdrop of the same, the A1 has a conspiracy in connivance with A2 and A3, and projected to him that they have good links in the department and can help in clearing the bills. And for the same, they asked for rupees 2 crore 40 lakhs 42,251. It is alleged that on 16/9/2024, the informant paid an amount of rupees 1,39,15,460 at Naharlagun through bank transfer. It is further stated in the FIR that after payment of the said amount, the accused person came to his office on 7/12/2024 with a letter number DO number P-17/1/20224/P-Roman 3 caps Roman 3, issued by one Rajesh Bharadwaj to the government of Arunachal Pradesh regarding allocation of fund of rupees 29,37,32,499 against his firm for the amount, and it was indicated therein about allocation of 15,46,32,437 against the firm of the informant. Stop. However, the informant had some doubts about the authenticity of the letter, as they had told him that it was sent through WhatsApp from Delhi, and they also asked for rupees. The accused persons also asked for rupees 1 crore 1,26,791. Stop. It is stated in the FIR that subsequently, when the informant went to the office of the chief engineer to ask about the allocation of the fund indicated in the letter, he was informed that no such letter has been received, and that the letter in his hand was fake, fabricated and manufactured. It is stated that thereupon he called A1 to return the money, and whereupon A1 told him that A2/petitioner had done this conspiracy against him, and that A2 is a habitual offender, and all the accused persons have shared the aforesaid amounts. With these allegations, the informant prayed for taking action by the police. Full stop. The case was registered and investigation is going on. Full stop. Mr. Dubey, learned counsel for the petitioner, submits that the petitioner and the informant, the present petitioner and the informant shared a business relationship in the past, and that the informant had also given a power of attorney to the petitioner, as part of which he was he was using his high valued car, and also paying some EMIs thereof. Full stop. Full stop.
Lord, as well as the bank account, my lord, because both are there, my lord,
Full stop.
in the schedule.
It is also submitted that the bank accounts were also shared between the parties in course of such business relationship. Full stop. It is submitted by the learned counsel that the dispute, if any, is of a civil nature, and that he has been falsely roped in by way of a criminal investigation by the informant by lodging of this FIR. And hence, he is praying before this court to invoke its inherent powers to quash such criminal proceeding. Full stop. The learned counsel has also drawn attention of this court to an acknowledgement made by the petitioner himself, where he frankly acknowledged transfer of rupees 2,40,42 of 251, and he also stated about taking responsibility for the aforesaid amount, and which has been partly adjusted as well. Full stop. The learned counsel has also drawn attention to a settlement deed dated 14/9/2025, drawn up between Tayo Enterprises belonging to the informant and Tauluk Lambi, the accused number 1 in the FIR. Full stop. The said agreement inter alia stipulates a return of rupees 4 crore to the informant. Full stop. As many as 12 witnesses have signed on the said agreement. Full stop. That will mean it. The learned counsel submits that in the entire facts and circumstances, the petitioner herein has been falsely implicated, and falsely implicated with regard to matters which are purely civil and business disputes, for which the remedy is not a criminal proceeding. Next paragraph. The scanned copy of the case diary as called for has been received. Full stop. Along with a status report of the investigation. The learned additional PP submits that there are materials against the petitioner, some of which have also emerged from the statements of the co-accused. It is submitted by the learned additional PP that the investigation is in progress, and it would be premature to quash the criminal investigation at this stage. It is submitted by the prosecution that having a civil dimension of the dispute does not mean that there cannot be criminal liability, and that it would depend upon the facts and circumstances. It is submitted by the prosecution that the scope of quashing would be limited at this stage. In support of his contentions, he relies on the following decisions. Next paragraph. Mr. Deuri, learned counsel for the petitioner, learned counsel for the informant, opposing the quashing of the investigation, submits that it is early stage and investigation should be allowed to continue. To stop. Drawing attention to the relevant para in the bail petition, Mr. Deuri submits that the contention that the informant got a contract earlier through the petitioner hearing is not correct. Stop. By way of reply argument, Mr. Dubey, learned counsel, submits that despite being given opportunity the prosecution order, informant has not filed any written objection. And therefore, it would not be justified to contain the statements made in the bail petition. Full stop. Next paragraph. I perused the relevant materials and considered the rival submissions. Also seen the judgment decisions cited at the bar. Full stop. The law regarding quashing of FIR is well settled. Full stop. In the cardinal decision of Bhajan Lal, State of Haryana versus Bhajan Lal, Supra, not Supra, full citation. Full stop. It has been held inter alia in paragraph 102. That you just will check the paragraph 102 most probably. That dot will reflect. Full stop. In the case of Niharika infrastructure, also versus so and so citation, the Honorable Apex Court also summarized the law regarding quashing of FIR, reiterating the basic principle laid down in Bhajan Lal. Full stop. Now going back to the facts of this case, this much. Complete there, otherwise it'll get late.
Take some time.
Okay, Mr. Dubey, you can log out. Okay.
Deeply.
You'll get it today only. I'll dictate.
Item number 11.
Please, Lordship. I am appearing on behalf of Learning Council, Arubeta Judging.
Oh, yes. She had come.
Yes.
She had come. I interacted with her. She does not have any problem. She also wants it to be quashed. So
And in that
this
case, my lord, yes, maybe quashed then.
can be quashed.
Obligement.
Stop. From our previous order, just a minute. Just a minute. That's previous order 37. You can take. Your good name, please.
Dimara.
And Mr. Totna Ate, learned additional people. Para 2, 3, 4, 5. All this. Scan TCR has been received. Up to 6 you take. Also. On the last occasion, the learned additional PP had. Have you checked the discrepancy? No issues. No?
So, my lord, since if she appeared, my lord, and I appeared before your
We
lordship,
brought
then,
her iCards also.
yes, ma'am, then it would suffice, my lord.
Mr. Ate, Learned Council had suggested appearance of the parties before the court today, which was directed. Full stop. Pursuant thereof, though the petitioner number 1 or 2, the wife, the petitioner number 2 appeared in person before this court.
Yes.
However, the petitioner number 1 did not appear, and it was submitted by petitioner number 2 that he has gone to Gauhati.
Yes.
And therefore could not appear. Full stop. Upon interaction, the petitioner number 2 has supported the agreement. Agreement dated, what was the date of the agreement? Agreement dated 10/6/2026. Recorded between her and the petitioner number 1, within bracket her husband, and expressed her desire for quashing of the criminal proceedings. Full stop. The petitioner number 2 also stated before the court that in recent times, the petitioner number 1 has not subjected her to any ill treatment. She said that. अच्छा हुआ है आजकल ऐसे he said like that. बोले बहुत अच्छा. Keep him away from too much liquor. That's very important for domestic peace. That is one. It starts from there actually.
Yes.
Too much, right? Liquor. Otherwise, the case is at the stage of, I've written, I think.
This case is the stage of, my lord,
As already mentioned earlier, the case is pending trial for the court of Larned GMFC, number 1 at UPS. Full stop. Upon perusing the materials and giving my consideration to the matter, including the submissions made before the court by the petitioner number 2 during her personal appearance, I'm of the considered view that it would be in the best interest of the parties to put an end to the criminal proceeding in exercise of inherent powers. Next paragraph. In such view of the matter, the criminal proceedings being GR 177 of 2020. Oh, so second bracket you like, right? Arising out of Itanagar Women PS 25 of 20 under so and so, pending before Learned GMFC 1 UPA are hereby quashed. You can, a copy of this order shall be sent to the Learned Trial Court.
yes, ma'am. Yes, ma'am.
Or you submit.
Yes, ma'am. Obliged, ma'am.
Okay, no problem. The criminal petition stands allowed and disposed of.
Item number 12 and 13.
One is AB, one is BA.
May please, your lordship. Item 12, my lord, is a regular bail application, my lord. The POCSO and Sacited matter, my lord. The accused has been behind the bar.
24 was dismissed for default and non-prosecution. Your Lordship, my submissions are that the counsel for the petitioner, we are based in Delhi, so we had engaged a local counsel for the said matter. We had filed the quashing petition in January 2024. And notice was also issued in January 2024. However, Your Lordship, after that, the dates were being given in the matter because the respondents, we took the steps and then the respondents appeared and then they started taking time to file their reply. Your Lordship, the difficulty that we faced was that our previous local counsel, she was not following the matter, and due to which some adjournments were given. And Your Lordship, we immediately changed our local counsel, and Miss Levina, who is present in the court today, we engaged her and she filed her wakalatnama and she diligently followed the matter. However, Your Lordship, on 31st of August 2025, till that date also Miss Levina was tracking it, and we have also annexed the case status, wherein which shows, Your Lordship may have the case status which is at page number 13
Yes,
of the petition.
May I see the impugn order?
Yes, Your Lordship. It is at page 11, Your Lordship.
Okay. We have to issue notice? Yeah.
My lord, notice was issued, my lord. In fact, in respect of respondent number.
It's not an issue.
Yes, madam.
Not a problem. But the thing is that it was issued. But
It was issued. Whether service is complete or not, my lord, we don't know, my lord.
Your Lordship, service.
To the
just a minute, madam, just a minute. I'm just having a look at the. Okay. It doesn't have to go to the same bench, right? Does it?
My lord, actually, that will be more appropriate if it is before the actually same bench, because my lord, but not required, my lord, so far as the restoration is, recall of the order is concerned. But my lord, whether the service, because the court has directed them to take steps upon respondent number 2 and 3.
Have you taken, madam? Yeah.
What-
Asking, look.
Yes, Your Lordship. Pursuant to the last order,
Mhm.
fresh steps were taken within the time granted, and notices were sent by speed post as well as by usual process to respondent number 3
Usual process, truthful session.
My lord,
at
then
all the available addresses on record, Your Lordship.
Your Lordship, also these are the same addresses on which the notice were issued in the quashing petition and the service was complete in the quashing petition.
There's only,
We have,
okay, Maya digging and Nilamani, right?
yes, Your
So,
Lordship.
let me check up the office notes. Service report of respond number 2. Person number notice, now it's fine, so. Will receive from matter, will do this out in some. Respond number 2 has been served.
yes, 3 notes, sir.
3 has not been served.
Yes, man.
What to do then?
Your
Who's-
Lordship,
On my lord,
Who's who's the informant?
Your Lordship,
my lord, we are
both of them are the informant, both of them were friends, and both of them invested in the business together. And the petitioners are also two young girls, and Maya and Neelam, both of them are all 4 of them were friends. And Your Lordship,
2 and 3. 2 and 3 both are victim complainant, my lord.
Okay, so
Both.
what to do about the notice?
My lord, 2 is, so far as 2 is complete, my lord. There is no any requirement, my lord. 3, 4, 3, my lord. Notice they have to take fresh steps, my lord.
Your
Your
Lordship,
Otherwise, not a problem restoring it. But the thing is that
Yes, madam, but
only the process
Yes, madam.
has to be completed. Would you like to, madam? Would you like to take fresh steps? Itanagar address only.
They have to verify and, my lord, they take steps, my through jurisdictional PS.
Or I'll just see. Said that it was unserved, return unserved, and so, Nilamani. Respond number 3 not found in the given address. Not
They
found.
have to verify it, my lord.
Your Lordship, this is the so there were 2 addresses. We have taken the steps thrice in the said matter. We served her on the address that was mentioned in the caution petition, and we again served her on the new address. We so this is the 3rd time that we have served her, Your Lordship.
Have a look. So probably some issue with the address. It is stated to be not there. So how do you negotiate this?
Your Lordship, respondent number 2 may be directed to inform because both of them are friends. Both of them filed this FIR. Both of them are the informants in the said petition, and both of them were appearing in the caution petition also. Their counsel was also same.
My lord, so far as my lord, this address, it will be very much difficult to serve in this address, my lord. It's a daughter of so and so, resident village Ganga. Post office Itanagar, my lord. I think, my lord, Ganga comes under RK mission also. My lord, even the post office is not properly been addressed.
Big area. No, big area.
Yes, my lord. So let it be through, my lord, jurisdictional police station, my lord.
Can it be?
Yes, my lord. Because usual course is through jurisdictional PS in criminal cases, to my humble understanding, my lord.
No issues. You're right. You take that.
Let it be through jurisdictional PS, my lord.
Apparently it's not a big thing. I mean, you want to prosecute the matter, you can prosecute it perhaps. But only thing we should not remain stuck in this procedural thing.
Otherwise also, my lord, even if it is recalled, my lord, in the main petition, they must be participate, my lord, because
Your Lordship,
they
they
will
were participating
they-
in the main petition.
because the main petition has been dismissed for default. Now, my lord, to recall this order, after recall of the same, my lord, the notice has to go because after recalling, they will not know if this notice is not served. So again, my lord, even if that will be delayed. So it's better if notice is served in this case itself, and from the next date, if it is recalled, if they come, then court will continue with the main criminal petition, my lord.
Your madam, your good name, please. Your
Ishita
good name,
Mishra,
please.
Your Lordship. Ishita Mishra.
Ishita Mishra. appearing online, through online mode from Delhi, assisted by local counsel, Madam. Yes.
Livina Jini.
And learned additional PP. Atish. Full stop. The IA has been filed by the petitioner, agreed by order dated 4/9/2025, passed by this court, dismissing the criminal petition for non-prosecution. Full stop. It is submitted by the learned counsel, Mishra, Mrs. Mishra, that the petitioner desires to pursue this proceeding, and that due to some miscommunication and laxity on the part of the earlier engaged local counsel, steps could not be taken and the matter came to be dismissed for default. The two complainants have been implemented as respondent number 2 and 3. Service upon respondent number 2 is complete as per the report. However, notice upon respondent number 3 came back unserved with the report that the addressee was not found at the stated location. In the said situation, the petitioner, the applicant shall take fresh steps upon respondent number 3. It will be
Madam, jurisdictional PS, police station.
it will be submitted to PP's office
No, madam, they have to take it, madam.
directly to the police.
Yes, madam.
Directly.
Yes, madam. Through madam registry only, madam.
Shall be fresh steps upon respondent number 3. Steps may full stop. Steps may be taken through the registry and to be executed through the concerned police station.
Yes, madam.
Whereafter prosecution can take instruction.
Yes, madam.
Regarding service.
Your Lordship,
Please do that.
please, I may be given a very short date because I had filed the restoration in September and it's already August. The FIR was registered 3 years ago. And the charge sheet has also not been filed in the matter.
I can give you any short date, week's time also, but provided this process is complete.
Yes, madam.
So how much time, when do you want it to be fixed? You can suggest a date. You can suggest a date after 2 weeks. Is it okay? After 2 weeks, date after 2 weeks. Since you will be appearing online, then we can give this August 3rd. 17th August. Is it okay?
Yes, Your Lordship, 17th August is fine.
17/8. Okay.
Let them take steps within a week, madam.
You take the steps. I won't say anything.
Yes, Your Lordship.
Okay. You can log out.
Much
Grateful,
obliged.
Your Lordship.
Item number 15.
Yes.
Lordship, you have me. Lordship, the office note indicates that service upon respondent number 1 and 2 are not complete. The
Unserved notice.
first is unserved but without an AD card. So it is not known whether it was.
Nowadays, actually, AD cards they don't come back. The speed post is not there. AD cards hardly come back now. You have to either the postal tracking you have to check.
Yes, sir.
Maybe.
Even in the body of the envelope they return, there is no endorsement made regarding the reason why the envelope came back. However, respondent number 2, it is reflected that he is out of state. So it is not known whether there is someone else who was in the house who refused or.
So what do you suggest?
My lord, respondent number 1, my lord, it is the official address of the company.
This should be possible.
My lord, we may take fresh steps because the
fresh steps.
Respondent number 1, at least respondent number 1, they are required, the insurance company.
Driver may not be, but owner also it's better if they stay. Next paragraph. Just right. Heard, Mr. Counsel. Next paragraph. As per office note dated 1/8/2026, service report in respect of respondent number 3, put in bracket driver, not yet received back. Full stop. Further, comma, unserved notice has been received in respect of respondent number 1 within bracket insurance company and respondent number 2 within bracket owner. 1 and 2, you take the first steps.
Okay.
The appellant shall take first steps upon respondent number 1 and 2. This is also a bit of a vague address.
The respondent
Amitpara
number
village.
2. Yes, my lord. However, my lord, basing on this same address,
District
they appeared
Udalguri.
participate in the trial, my lord.
This is possible. They'll find it. This is a proper address in Gauhati. Right. So you take fresh steps on. Take fresh steps. List after
2 weeks more.
2 weeks.
3 weeks. 3 weeks.
3 weeks.
Much alright.
Item number 16.
The service of a respondent is still awaited, Your Honor. Sole respondent.
Just. You have checked the office,
Yes.
no? Learned counsel. Your good name?
M. Taso, Mindo Taso.
Tasu. Learned counsel submits that as per office note dated 1/8/26, service report is awaited with regard to the sole respondent. Okay. List after 2 weeks.
Yes, sir.
Short break.
Item number 17.
May I, Your Lordship? Your Lordship, I am appearing on behalf of respondent number 1 to 10, Your Lordship. And we have already filed our wakalatnama, and also we have filed affidavit in opposition also.
Yeah. I have received the copy also.
You have received?
Yes.
Just a minute. One to 10.
1 to 10, Your Lordship.
And what about 11, 12, 13?
What, we have sent the copy also.
Head Gambura. Do you need to make them parties?
Not necessary.
And head Gambura.
Not necessary.
Huh? The order was, you are challenging the order passed by Gamburas.
Yes, Your Lordship.
Kebang.
They are challenging, Your Lordship.
Challenging, yes.
Your Lordship, 11, 12, and 30, they are the head Gambhuras of that different villages, Your Lordship. They have passed an order, but therefore they have challenged that order, Your Lordship.
Oh, service is complete.
Service is complete.
On all 13.
complete.
All 13.
Your Lordship,
So-
however, in this case, Your Lordship, TCR is yet to be called. Your
Oh,
Lordship.
that is
Here may
difficult.
be
What we
required.
can do, we can admit it, send it for hearing.
Yes, Your
In
Lordship.
the meantime, we
Meantime,
can get
TCR
the
will come, Your
TCR.
Lordship. Huh.
So then, these respondents need not detain us.
Yes,
Service is
yes, Your
complete.
Lordship. Huh.
Heard, Mr. Learned Counsel,
Tinega.
for the petitioner and Learned Counsel
Ring
for respondent number 1
1
to
to 10.
10. Full stop. Next paragraph. As per office note dated 4/5/2026, served notice has been received in respect of all the 13 respondents. Though respondent number 1 to 10 are now represented, but none appears on behalf of respondent number 11, 12, and 13. Though service is complete. An affidavit in opposition has also been filed on behalf of respondent number 1 to 10. Good stop. The learned counsel for respond number 1 to 10 points out that the case record from the learned court below is yet to be procured. Accordingly, issue requisition for the case record of DRJ/CA, right?
Yes, sir.
Number 9 of 2025 from the Court of the Learned Civil Judge Senior Division, Daporijo. This is in which district it will be?
Upper Subansiri.
Upper, yeah. Upper Subansiri. Good stuff. Scan copy will do, right?
Yes, Your Lordship.
Scan TC. Scan TC. Good stuff. In the meantime, the revision is admitted for hearing.
Yes, sir.
And list in the orders column. After
Your Lordship,
receipt
it will
of
be listed in the admission column since meantime the
No, if we admit it won't be in the, we can fix it for hearing.
for hearing, no?
Yeah, there's no problem.
Yes, sir.
Admitted for hearing, list in the orders column after receipt of TCR.
Yes.
Okay, scan TCR. Should we leave it to the registry?
Yes, Your Lordship. After 2 weeks.
There is an entry, continue.
The interim order, white order dated so and so.
Order the 603.
6/3/2026 shall continue till the next date of listing.
Always.
Hello.
Item number 18.
My lords, if I may.
Yeah.
My lord, we had prayed for fixing this matter today as the execution case in regards to the order that is being challenged is fixed tomorrow, my lord. So
yeah.
although it is listed in the orders column,
Pardon, this, can you repeat?
my lord, we had prayed
Mhm.
through an IA on the last occasion to fix this matter today.
Today,
As the execution case before the learned trial court
Mhm.
is fixed tomorrow, my lord.
Execution case.
Yes, my lord. My lord,
Execution regarding?
in this a revision order passed by the learned session court, allow, my lord.
For enhancement of maintenance to the child.
Oh, sir, maintain.
Your Lordship, before my friend make any submission, Your Lordship, earlier this matter was conducted by one of the counsel, Your Lordship. And when I made my appearance, a copy of the petition was to be served to me, Your Lordship. I have been served with this copy, Your Lordship, which does not contain, it's only till page, it does not contain the entire copy of the petition, Your Lordship. And on the other instances, I had asked the council to furnish me the entire pages, copy of the petition with the entire page, Your Lordship, which was not done. And on the last occasion,
You furnish her a copy. Furnish her.
on the last
My lord,
occasion,
we could-
my friend has newly been appointed as a counsel, Your Lordship, where he had filed an IA for preponing of the case today, Your Lordship. If I may just pray, Your Lordship, if this matter is taken tomorrow otherwise, and meanwhile, he may furnish me the entire set of the copy because
Okay. Is it, do we take it, I mean, the case is ready for disposal or what? Is it ready for
Yes.
disposal? Record has come. Any records? Record has not come. Shall we need a record? Need the record?
because
We'll need
if
the
the
report,
entire
no?
petition is being given to me, Your Lordship,
Then we'll call for the record
because
quickly.
the one I have, Your
Uh-huh.
Lordship, this is the petition that was filed in Sessions Court, Your Lordship.
Revision, maintenance was given. 125 maintenance.
It was enhanced, my lord.
No, 127.
Yes.
It was-
Actually, my lord, before the learned session court,
Mhm.
the rejection order by the learned CGM was challenged, whereby the prayer for enhancement
Oh,
was rejected.
no, prayer for enhancement was made before magistrate, rejected. It was, appeal was filed, sorry, revision was filed to the
Before the
sessions
learned
court.
session.
What happened in sessions court?
From 10,000 per month, it was enhanced to 30,000.
330.
30, my lord.
So now the husband has come.
Now the husband has come saying that I don't have the financial
Okay, he thinks
capability
that
to
the
pay.
enhancement to that extent was not justified.
Not
So he's
justified.
come. I understood.
And also, my lord, actually the main issue here being that in the revision.
She's
or-
getting 10,000.
she's getting 10,000, and that is being willingly
Not,
paid by the petitioner herein.
Not 10,000, Your Lordship, only. Also, he was supposed to be giving the school fees, Your Lordship. And since the passing of the order in 2017, Your Lordship, it was only in 2022 when he had paid for the school fees of the child, only once, Your Lordship. And that's when the enhancement petition was filed before the concerned court, Your Lordship. So the subsequently in the revision petition, the enhancement was made to be 30,000, Your Lordship, which has been challenged in this petition.
My lord, our difficulty, why we had prayed for this date today, was that, my lord, in their execution petition, they have also, in the revision order, there is a direction to the DDO of the petitioner to deduct. So that is our apprehension, my lord, that during the pendency, if the deduction starts, my lord, we'll be in grave financial peril, my lord.
Your Lordship,
My lord, and mainly this today, it was for the consideration of the interim prayer, my lord, because the interim has not been considered till date, my lord. So we were praying that the interim, our interim may be considered, my lord. It is not that we are not paying, my lord. We are paying, my lord. And we are willingly pay also, but this 30,000, my lord, this enhancement that was being done, there has been no justification in the impugn order regarding this.
He's a service holder or
He's a service holder, my
He's
lord.
a chief engineer.
Yeah.
Huh?
He's a chief engineer, Your Lordship.
Chief engineer.
Chief engineer.
Will be getting the
Yes.
salary.
Yes, and he
My lord, but my dependents, the numbers that I have also detailed are
Your Lordship,
quite a few numbers.
Your
my
Lordship, otherwise I'm also ready for the argument on interim. If only the petition is being properly served to me, tomorrow we can take up the case, Your
Okay.
Lordship.
Okay.
My lord, then we had a small prayer, if it can be considered, my lord. My lord, if the matter is to be taken up tomorrow, my lord, I only pray that as the execution matter is tomorrow, no order may be passed by the learned trial court directing deduction by the DDO till tomorrow, my lord, till tomorrow. If tomorrow the hearing is done, my lord,
Tomorrow hearing is not being done. Execution, just as
No, no, I'm just saying.
execution order has been placed in the IA, Your Lordship will see in the execution order, there has been a direction for service of the copy and for filing of the reply. We have not entered our appearance till that. Only service is being made, and tomorrow is only for the appearance, Your Lordship. Execution has not proceeded per se, only till the issuance of notice, Your Lordship. And also, if there is any deduction that can be managed or added or subtracted on the later stage, Your Lordship.
My lord, there is nothing.
The order was passed in the year 2017, Your Lordship, when the child was only in the nursery school, Your Lordship, an amount of 10,000. Now he is in class 9, Your Lordship.
And
And 30,000.
he's chief engineer in which department?
PWD,
No, I mean,
PWD department.
they must be getting a decent salary, you know. Anyway, so
My lord, our only prayer was that for
some
regarding the
enhancement will
deduction,
be justified, I think.
Yes.
some
yes.
Some
enhancement,
enhancement will be justified.
Yes.
but not 30,000, my lord. And
So
also,
it
my lord,
depends, everything, it depends how much a person is, see, 30,000, a mother and a son in today's times, you know, for a reasonable living, 30,000.
In fact,
my lord,
But it depends on how much the person is earning.
yes.
My lord,
In fact, the wife has not claimed for the maintenance, Your Lordship.
Only for the child.
Only for child, and also
Have they submitted their income affidavits?
yes,
for the-
they have not submitted, and their submission was that
Because it
for the
leads to
sake
more delay.
for
So
the
there are decisions where maintenance passed orders without, perusing income affidavits are again remanded.
yes, and therefore we
It will waste time.
have filed our affidavit assets of assets and income, Your Lordship, and on their part, even during the revision petition, they have stated that for the sake of brevity, they would be relying only on the miss case, Your Lordship. They have not submitted any assets or affidavit of income.
And that is necessary.
Even when enhancement was being made,
That is necessary.
yes, that's necessary, and that was only their claim and statement written in the petition. That's what Your Lordship may take up this matter tomorrow, and Your Lordship can hear it, Your Lordship.
my lord, if I may.
No, because why have you not, because for interim order, you have not submitted your income affidavit on, that is a must. Government servant especially, everything is on paper, right?
My lord, that I believe will come with the my lord, one aspect that I may be allowed to submit, my lord. The wife, my lord, the respondent herein, my lord, she's also earning 2 lakhs, my lord.
No, that's absolutely wrong.
No,
Sorry.
let her, she also file her affidavit.
Yes, I have filed my
So
affidavit.
my lord, the order by the
You have filed the affidavit.
That's in the record along. That's why what I'm trying to apprise before this court is that even during the revision petition, we have filed our affidavit of assets, which was never brought in record while filing this petition.
During the proceeding before magistrate, did they file the affidavit?
No, we have filed before the magistrate and before the sessions court in the revision.
Must also file.
My lord, there is nothing reflected in the order before the
Why
learned
you have not
magistrate.
filed? That is, adverse inference may be, drawn because you're trying to hide your income or something. Because you must also file, isn't it? Then only you have the, right to seek a interim order. So, you must also file, but okay, I'll hear the interim prayer with an open mind.
My
Maybe pay something in between and then continue with the disposition.
My lord, there
But
is
the thing is that, no point directing someone to pay something which a person cannot pay. Suppose if my income is say 50,000 and you ask me to pay 1 lakh, how I cannot pay? It's not possible. Therefore, if people truthfully state, there's also an element of trust also. That affidavit, if people truthfully state their income and liabilities in the statement, the maintenance order should be correct.
Yes.
That's why this has been laid down in Rajneesh versus.
Yes, yes.
That is the philosophy, that to arrive at correct orders, correct amounts.
Yes.
Blind guessing is very risky. So if the court has a reasonably good idea of what is her, what is the income and what is the paying capacity, then only you'll have correct orders. And correct orders will make it possible to more easy to implement also.
Yes. Yes.
My lord, that is why, my lord, if my lord will see page number 35, which is the order by the learned trial court, my lord, the magistrate, my lord. Therein the magistrate has discussed why the enhancement was rejected, giving cogent reason, my lord, that why this.
Where our page number?
Page number 35 of the petition, my lord. If my lord will see page number 35 of the petition, my lord.
No, it is reflected. She's earning 1,50,000.
Oh, my lord, the para number 10 there in the.
And he's earning
Yes, my
one
lord.
38,000. Well off couple, that means.
10 and then para 10, because my lord.
In fact, both the parties are
They're well
earning well off. They're well off.
They should give a good, upkeep for the child, both of them. Both of them.
In fact, this matter should all, if I may suggest, Your Lordship, this such kind of matter which deals more particularly with child, Your Lordship, this kind of matter should be actually referred to the arbitration, Your Lordship.
Yeah.
So that both the parents can come and at least come to
Family
a
law,
conclusion.
ADR should be the engine.
Yes.
in family law and civil as a whole nowadays. You see internationally, ADR is the engine of the civil justice system. Anyway, that's.
My lord, the expenditure.
Ground. So she was not convinced. Actually, the magistrate probably looked due to the salary, a reasonably good salary.
And also, my lord, our para, this page number 14
But
of
you
our
do
para.
file the affidavit. How did she come to know that you are earning 1,38,000 from your statement? No, the magistrate held or the magistrate in the order it is written that your client is getting a salary of 1,38,600.
Because we participated before.
So you on the basis of affidavit.
On the before.
Not the income affidavit. The statement. General.
You'll have to verify regard because you have to see the case.
He may have filed also. Please take instructions because otherwise how will the magistrate come to know? Anyway, we can hear. Tomorrow is DB, but we can hear.
Yes, sir.
These are matters are
Yes.
important.
Except if the
You can
proper
fold it up
copy.
within an hour, half an hour, finish. 40 to 45 minutes to finish.
Yes.
Not much to argue on this thing.
Yes, yes.
Just write your points and argue.
Also, the petition proper petition copy.
The Genie Learned Counsel appearing for the respondent. They are married or separated?
They are living
They are not
separately,
mutually. They are not
legally, but
divorced,
living
but-
separately. For the respondent wife, submits that after her entering appearance in the matter, she has not received a complete set of the petitions and the annex documents, and prays for furnishing her with the same. The petitioner side shall do the needful in this regard. It is submitted by learned counsel for the petitioner that the matter is fixed for execution tomorrow. That is 4/8/2026. The gist of the matter is that the respondent herein had filed a petition for enhancement of maintenance granted to her child, within bracket petitioner number 2, but the same was refused by the learned magistrate, whereupon she preferred an appeal before the sessions court, which enhanced the existing maintenance of rupees 10,000 to rupees 30,000. Full stop. This time, the husband, being aggrieved by the said enhanced amount, has preferred the instant revision. Full stop. It is submitted by the learned counsel for the petitioner that the existing amount of rupees 10,000 has been paid, is being paid by the petitioner. Full stop. Ms. Jeannie, learned counsel for the respondent, prays for fixing the matter tomorrow. Okay. Is the matter tomorrow, that is 4/8. What kind of interim order?
My lord, only that part, my lord, there no direction to the DDO for deduction, my lord. Since it is only till tomorrow.
My submission would be, Your Lordship, even if it's deducted, Your Lordship, it's not going to any hair-free person, Your Lordship. It's going, and it can be later on, if Your Lordship finds out that the enhancement has been correctly done or has been wrongfully enhanced, Your Lordship.
And another thing, madam, tomorrow we will be hearing on the interim prayer.
Interim prayer.
Okay, because the final adjudication might need the records.
Execution, they have not challenged till date, Your Lordship.
Execution?
No, the final adjudication of the enhancement.
Enhancement, yeah.
Might require the records.
Yes, Your Lordship. Tomorrow is only for the interim, Your Lordship. So if that deduction part that they are praying only for tomorrow, Your Lordship, that deduction part, my submission to that is that 30,000 will be deducted if deducted from tomorrow, Your Lordship.
You kindly take the learned counsel for the petitioner shall also take instructions from the party as to whether he had filed the affidavit of income, assets, etc. before the learned courts below, in terms of the judgment of the Honorable Apex Court in Rajneesh versus Nehm. Good stop. Next paragraph. On the prayer of the learned counsel for the petitioner, as the execution matter is fixed tomorrow, and the prayer for interim stay of the impugn order is being heard tomorrow, it is observed and directed that till further orders, we'll say it like that.
Your Lordship, until further, Your Lordship, it's just tomorrow. Your Lordship is well aware that today the order won't be available in CTC copy, Your Lordship. They won't be able to send it to the concerned department. Tomorrow the matter will be coming up for interim order. Then yes,
Don't pass any orders.
Just an observation.
You take the instructions about it, sir. Tomorrow.
Yes.
Tomorrow
the
the
hearing will
interim
be done
can be
tomorrow.
here.
Only,
I'm
my
also
lord,
ready, Your Lordship.
because till tomorrow, my lord.
It's
Till tomorrow.
already an office time is over, Your Lordship.
Till adjudication of the prayer for stay of the impugn order dated. Help me with the date. 18/12/2025. So, comma, the learned executing court shall not pass any orders, may not pass any orders for deduction of amount shall not pass any orders to the concerned DDO of the petitioner for deduction of amount from his salary bill. We'll hear it and then pass an order. You try to work out, settlement that it's best actually. That not even with regard to the stay, you that will state that you will pay this much. If you can work it out, it will be good. And you take instructions. You ask him that. Also take instructions whether he has filed affidavit, because this figure the magistrate won't arrive on his own. He must have had some.
And in fact, since they have not brought it they have not brought it into record, my petition, Your Lordship, with entire affidavit of assets, Your Lordship, I was to be filing my reply, and the matter was therefore fixed on 14th. However, because of the execution petition, they have responded the matter, Your Lordship. Deep view.
Item number 19.
It's come up for. It's come up for orders.
My lord, this stay order may be vacated because execution proceeding has been stayed by this honorable court. This has to be vacated, you know. The decretal amount 91 lakhs.
You're for the respondent.
Yes,
You have entered appearance.
And for the petitioner.
Your Honor, this honorable court has given conditional interim order on 24/4/2026 by saying that 91 lakhs has to be paid by the JD, the petitioner hearing.
It's arising out of a money suit.
Yes.
Money suit.
Lordship.
Just a minute. Just a minute.
Because of this stay order, the money, that execution petition is pending here. Out of 91 lakhs, they have paid only 5 lakhs. After giving last opportunity by this honorable court.
Which is the order you were mentioning? Order dated?
3/7.
3/7. Yes.
First order, Your Honor, 24/4/2026, that is the conditional interim order has been granted. And then subsequently order that 3/7/2026, that was the last opportunity has been given. On 18th, then 21/7/2026 order. On 18th, they are submitting that they have deposited 5 lakhs to my account. Out of 91 lakhs.
Lordship.
After giving last opportunity.
In our petition, your lordship will see, we have, in our prayer, we had not prayed for putting stay on the execution petition. We have only challenged the civil warrant issued by the executing court. And lordship, the
warrant was stayed.
Yeah.
If the stay is vacated, that warrant will be liable to be executed.
Correct.
Yes, Lord.
But it was, now my hands are also tied because the earlier, the bench in the earlier dates had given last opportunity.
Last opportunity.
So in a way, this court is bound by that, isn't it? And he is not paid.
Not paid.
Lordship, if I may. Lordship, we are only challenging the warrant passed by the executing court, stating that the warrant passed was non-justifiable. And Lordship, the Honorable, this court has directed us to pay the amount, and we have paid 5 lakhs out of the total decreed amount.
The amount is
91 lakhs.
1 lakh.
Total decretal amount.
And
that too is consensual order, Your Honor.
And I beg to stop.
Where? Which one? Just a minute.
That amount, that decretal amount, that is.
Is it there in the order? Is it there in the petition?
Yes, it is
Order.
there.
Page?
Your Honor, it is page 23.
Was a Lok Adalat?
Lok Adalat.
Oh.
Yes.
After settlement between the parties, then Lok Adalat has passed this order. Total amount is, Your Honor, 2,36,90,000. That has been settled down in 91 lakhs.
September 2025 itself.
Correct.
Within a period of 4 months. Not much scope, I think. Difficult.
Lordship, if I may.
Yes.
Lordship, we are accepting the liabilities that we are bound to pay the amount. But at this point of time, what I meant back to state that, Lordship, we have submitted 5 lakhs, and further the petitioner herein is facing difficulties because he has the properties in immovable format only.
And so in my, in my humble opinion, Lordship, as the execution petition is already ongoing on the executing court, and we did not seek stay on the execution petition. And so my opinion is that if the matter is endorsed back to the executing court, directing that the petitioner herein may appear and pay the decretal amount, then the petitioner herein will have a wider scope for the execution of the execution petition by way of liquidating assets and.
By setting aside the civil warrant.
Yes, and if the petitioner herein, civil warrant may be issued by following due process, because the instant civil warrant we are objecting that it is not justifiable, because we were not granted any opportunity to explain ourselves.
No, Your Honor, in their petition itself, page 41, notice has been received on 10/3/2026.
This is only postal tracking number.
19/3/2026.
Has three
Page 41.
That 19/3/2026, they have received the notice. They have received the good opportunity.
Page 40,
Order of 19/3.
43.
No, Your Honor.
Part of the date is not visible.
Yes.
Notice was prepaid.
In the executing.
I think this order, 9/4/26. 9/4/26. Notice was issued to prepaid
19/3/2026.
registered post and same is delivered as per postal tracking.
Yes, it is
Issue
only
civil
the
warrant.
postal track. And the petitioner has three residences, Your Lordship. The postal tracking ID cannot ascertain that if the notice has been reached in the hands of the petitioner or not.
No, that too, yeah, that we cannot take a
cannot be-
hyper technical view. Because it has reached this as address, that means we have to take it as receipt.
Yes, correct.
Because when the person has,
They are making
when
it
the
as,
notice has reached my known address, then it has to be taken as receipt, you know.
that's mere excuses. After coming before this honorable court, they are taking time and again, Your Honor, last opportunity is given by this honorable court. Twice they have got. After that, they have deposited 5 lakhs by saying that I am difficulty and so and so. Same excuses making earlier also.
Our simple submission is that in before this honorable court, we are facing difficulties to make the payment because we don't have enough funds for the.
It's a huge amount.
And because in the.
But it was settled in Lok Adalat. This is not
Yes.
playing hide and seek.
Yes,
right?
Lordship.
The Sotil said there was no compulsion on you to settle.
And Lordship.
Lok Adalat is consensus.
Consensus, Your Honor.
There was no compulsion on him to settle,
Correct, yeah.
but he settled it.
Yes.
Yes.
But now he's
Out of your
trying to avoid that commitment.
yes, Your Honor, that was out of more than 2 crore rupees. We have settled down because same story was before the honorable Lok Adalat. Then party has settled down in 91 lakhs from 2 crore. Your
The
Honor.
suit amount 2 crore was after interest and everything put on by them. And Lordship, we are not avoiding payment. We are just saying that we take the liability, but at this forum, because in their execution petition, they have also annexed our immovable properties of the instant petitioner, which shows that they have other means by way of attachment sale. So there's no chance, no question of us absconding.
No, Your Honor, that is the procedure of execution only. By annexing.
Can you take?
So therefore, my humble request, Your Honor, kindly bracket this.
Heard, Learned Counsel, Mr. Jamo? Learned, you are Mr.
Koda upper.
Learned Counsel for the sole respondent, Mr. 24/4/2026 order, second para you take. Full stop. Next paragraph. On 24/4/2026, the order dated 9/4/2026 issuing the civil warrant of arrest was stayed on the undertaking of the petitioner to pay the decretable amount. Stop. Subsequently, on 3/7/2026, some more opportunity was prayed for on behalf of the petitioner to take instructions and for the payment, full stop.
Lordship,
Full stop. As mentioned in para 4 of the order dated 3/7/2026, this court, in para 5, sorry, this court granted last opportunity to the petitioner to pay the decretal amount and in lieu thereof kept the civil warrant notice of civil warrant arrest in abeyance. Full stop. The relevant para 5 of the order dated 3/7/2026 is reproduced here in below in its entirety. Yes, please.
Lordship, in the order dated 24/4/26,
that is the first order.
it has, if I may read it,
No, because he's just right now. He's 24/4
order dated 24/4.
page.
Your Honor, that is the first order,
First
the
order.
impugn order.
Yes, I've said, I've reflected from there also.
It has given, like, shall not give into effect, given effect to subject to payment of that decretal amount. It is pointing towards the main money execution. It is not of the warrant issues or the order wherein a warrant was issued. It is the stay of the execution petition itself. And we did not, in our prayer, we did not mention, we did not pray for the stay of execution.
The order, the impugn order is about civil warrant arrest. That is the impugn order is about, the impugn order is only the civil warrant, right?
Civil warrant.
The revision has been filed only against the civil warrant.
Yes.
It
seems
That is whole of my execution petition, Your Honor.
It may be mentioned here in that the respondent, sole respondent herein had filed money suit, within bracket money suit MS number 33 of 24 for recovery of money in excess of rupees, recovery of amount of rupees 2,36,90,000. Full stop. Subsequently, before the National Lok Adalat on 13/9/2025, the petitioner and the respondent arrived at a settlement whereby the amount was quantified at rupees 91 lakhs to be paid by the petitioner within 4 months. Subsequent next paragraph. However, despite the elapse of 4 months, as the petitioner, who was also a signatory to the agreement arrived at in the Lok Adalat, did not pay the amount, the respondent initiated an execution proceeding within bracket execution petition number 1 of 2026. And in that said execution proceeding, by order dated 9/4/2026, civil warrant of arrest was issued against the petitioner, who then filed an instant revision challenging the same. It is submitted that he was not properly noticed before issuing the warrant of arrest. The learned counsel for the respondent counters this by drawing attention to the order dated, what was the relevant order? Order dated 9/4/2026, in which the learned court below has referred to the postal tracking report and indicated delivery of the notice on 19/3/2026. But the JD was absent on that day without steps. Thereupon, the civil warrant was issued. Next paragraph. Coming back to the order dated 3/7/2026, it was clearly held that the petitioner is being given last opportunity to pay the amount, and stay was granted on that condition. Full stop. Next, in the context of the above, as no further payment has been made by the petitioner, I find force in the submission of the learned counsel for the respondent that the stay may be vacated.
No, Your Honor, after 3/7, 5 lakhs has been deposited in my account. That has been
No
reflected into
No
21.
no further payment after depositing rupees 5 lakhs.
Correct, yeah.
Full stop. So we vacate the order.
Yes. Let the execution petition be continue.
In the said facts and circumstances, there is no option but to vacate the order of stay granted initially by order dated 24/4/2026. And accordingly, the same is vacated.
Grateful.
So this will otherwise call for the records. Will need the records.
Not really required, Your Honor.
For disposing this. We'll have to dispose of the civil record.
Yes.
Records will not be necessary.
Record is not required, Your Honor.
Or without records also we can dispose it of.
Record is
Because-
for review, well and good.
Because this petition is,
Call for a scan TCR from the learned court below with regard to execution petition number, Civil Judge Senior Division Pasighat. Execution 1 of 26.
22.
Execution 1 of 2026. List after 3 weeks.
Your Honor, fixed date may be given.
You can suggest it.
Your Honor, can it be on 20th of this month?
20.
Yes, 20 of this month.
20. Sort it out, you know.
Grateful.
It was already settled in Lok Adalat.
Yeah.
There should not be any execution
Yeah,
proceeding
correct.
after settlement in Lok Adalat.
Correct.
It defeats the spirit of Lok Adalat. They try to work out a settlement.
In fact, Your Honor, they are coming here,
Then
just
you-
buying their time, buying the time.
Then the executing court can recall the warrant.
Correct.
Yeah, that's true. I mean, should not play hide and seek. Because these things are delayed, you know, even after getting a decree, people don't get, they have to run around.
Yes. Grateful, Your Honor.
Item number 20 and 21.
Out of time, how about one, 20 and 21. Yeah, that's
Lordship,
what it is.
In this matter, Lordship, pleadings are completed. So, Lordship, we are jointly Friday matter may be listed day after tomorrow in admission.
It can be fixed for hearing also.
The admission hearing, Lordship. Lordship,
So, what is the matter?
matter is
We are on the IA or the CRP?
IA, Lordship, both may be taken up together because the petitioner has not filed reply in IA, but they have filed reply in affidavit in main case. So IA is for the vacating because there is an interim order. The issue before your Lordship is very simple, Lordship. There was an Kava. Kava was passed in my favor. So the present petitioners, they have filed appeal. And in filing appeal, there was a delay of 122 days.
Which was not condoned.
Not condoned. That point has to be determined whether the IA application for condemnation was with sufficient cause or not. That has to be seen.
That is the subject of the civil revision.
Yes.
Civil revision.
Yes.
Okay, and the IA in the civil revision is for state.
IA is for Lordship. The interim order was granted
Okay,
to the
this is-
petitioner. So this is IA for vacation.
Nice.
Vacation of interim order. But since
The final matter can be finally heard.
matter can be
Day
heard
after tomorrow.
Yes.
day after tomorrow, Wednesday, in admission column, Lords.
The interim order may be extended.
Both the learned councils submit that pleadings have already been exchanged on the civil revision petition, which has arisen out of dismissal of delay condonation petition filed by the
Present petitioner.
petitioner, filed by the petitioner. Full stop. The learned councils pray for listing the matter in the admission column on Thursday.
On 5th.
List on Thursday.
Your Lordship, interim order may be.
Interim order, white order, so and so stands extended. That means if we dispose of the matter altogether, then this will not be necessary.
No. But let it be there, IA be there.
Matter number 24.
Highly obliged. Deeply obliged.
My lord, in the first order, my lord, CD was called for, my lord. That has not been received, my lord.
Question of FIR.
Yes, my lord.
Okay. Case diary received.
My lord, case diary we have not received, my lord, because the concern or IO was on medical leave, my lord. So we may be given further time, my lord, we'll produce on the next date.
The scanned case diary of Likabali PS case number 17 of 2026 was called for but not yet received. Issue press requisition.
Yes, ma'am.
List on.
My lord, on the date, my lord, interim may be considered, my lord, because we were waiting.
And we'll go for disposal. Why on interim, my lord, if the CD comes? So everybody is represented, my lord.
We'll see. List on, we can take it when do you want, please.
My lord, 13, my lord, 13th of August.
1-3?
Yes, my lord.
13 will be too early, my lord. Let it be on 18, my lord. Perhaps.
Why? CD, you can get it, I think. You are appearing for the informant.
Yes, I am for informant. Respondent number
His
2.
name, Learned Counsel appears for
Kodappa.
respondent number 2.
Yes.
Informant.
Let it be on, my lord, 17, my lord. At least a week, my lord.
17.
Yes. Obliged, my lord.
13 is more.
Matter number 25.
This matter is fixed for referral to mediation.
Yes, yes.
As on today, my instruction is that there is no scope for mediation.
Okay.
Yes.
Same.
Therefore, my lord, this matter may be fixed for admission hearing after 2 weeks.
It is submitted by your Mr.
R.L. Tungan.
Tungan and your good.
Echitopuman.
And Learned Counsel, Mr. Tungan and Learned Counsel for the respondent. Mutually submit that though this case has come up today for exploring the possibility of referring for mediation, but as per their instructions, the parties do not seek referral to mediation, and that there is limited scope for the same. The Learned Counsel seek a regular adjudication of the appeal. Accordingly, list the matter. It has been, we can admit it also. We can admit it also. Records have come.
Yes.
The records have already been received from the Learned Court below. We'll let us admit it, then it will come for hearing. That will be best. Therefore, the appeal is admitted for hearing. No fresh steps be taken. List in the hearing column after 2 weeks. It's 24 matters.
That from. Matter number 26.
Yes, madam.
My lord. I'm appearing on behalf of the conducting counsel, Udica. We are appellant in this instant case, and I'm being instructed by the appellant not to refer the matter in the mediation for redressal. So the matter may be taken for regular trial.
Anyone appeared from the other side?
No.
No, none, they have not appeared. The appeal was admitted on 6/2/2026. Full stop. The matter has come up today for exploring the possibility of reference to mediation. However, the learned counsel, your good name, please.
Topi Bomjen.
Learned counsel for the appellant seeks a regular adjudication, submitting further that as per our instructions, there is less scope for mediation. As per office note dated 1/8/2026, service report awaited from R1, respond number 1, and unserved notice received back from respond number 2 and 3 due to insufficient address. So what will you do? Take fresh steps? The appellant shall take the fresh steps upon respond number 2 and 3. 2 and 3. Or would you like to? No, driver, it's okay. You can wait. It's not essential. 2 and 3, you take fresh steps.
Much obliged.
The appeal is being sent back to regular adjudication mode for the moment. First. Records have not been called for. Also call for the original TCR of MACT case number 4/24 from the MACT, learned MACT, Bomdila. Full stop. List in the orders column after
2 weeks.
2 weeks.
Much obliged.
I wanted to take one hearing, but no time.
I beg to mention this item number 28. This case was prefixed for the hearing.
38.
28.
28.
So, Lordship, it will take time. And also the respondent too is, she has advised that the next date may be fixed. So,
No, then there will be no time also today.
yes, sir, Lordship. Lordship, this case is pending since 4 years.
Yes, yes. He's in custody?
Yes, sir.
He's in custody?
Yes, Lord.
Get it fixed.
Monday, Lordship.
Monday, yes.
Monday.
He'll give you the dates.
Yes.
He'll give you the dates. No problem. He'll give you the dates. Others also, 30 to 33 also, you'll give the dates.
Alia,